For delivery of judgment. File number 1, criminal petition 74 of 2021.
Petition dismissed.
Number 2, criminal division petition 107 of 2018.
Dismiss.
Item 3, TRP 27 of 2026.
The appellant is accordingly directed to furnish a copy of the memo of appeal with connected documents to the learned counsel for the respondent number 1 during the course of the day.
Yes, Lord.
Course of the day. Office not dated. (21/4, 2026) indicates that no step has been taken by the appellant herein upon the respondent number 5. Learned counsel for the petitioner submits that he may be allowed to take fast step upon the respondent number 5. They are allowed. Step be taken by speed post and also by usual process within a week from today. Leaves the matter after 4 weeks.
Let's say date may kind of interim may be continued.
Interim order passed earlier shall continue.
Obliged, Lord.
Item 20,
I'm getting coming over 5, 10, 11, 12. Last occasion also they are not prepared.
None appears for the appellant on call. How about Mr. NC does learned counsel for the respondent number 5, 10, 11, and 12 present. It appears that the appellant remained unrepresented on 27/2/2026 and also on 21st of August 2024. Today also, the appellant remained unrepresented. And in view of above, this RSA stands dismissed for non-prosecution. Rest shall return the record of the learned trial court if called and the first appellate court if already called for.
items for admission. Item number 4,
Yes, please allow. Well, this is a writ petition which was filed, my lord. Subsequently, it was converted to my lord 227 petition. My lord, challenging the order of the my lord learned district judge, my lord, in the land grabbing case, my lord. Now, my lord, before I take your lordship the judgment, my lord, the case, well, briefly, the facts are like this, my lord. The my lord complainant, my lord, who is my lord who lodged this complaint, Afaz Ali, my lord. He is no more, but he has been his daughter, perhaps, or is someone else, my lord. He has been substituted by the person who has purchased the land, my lord. Now, my lord, he, my lord, claimed that, my lord, the land belonged to his my lord, Afazuddin Sheikh, my lord. Now, he gifted this land to his second son, one Azizur Rahman, in 1982. And that said, Azizur Rahman, she is also no more, no longer there. he gifted this land to the complainant on 4/1/2007 by a deed, registered deed. And he claims to be in possession. In para 5 of the petition, he claims that in the middle part of May 2015, page 18, the petitioner before lordship, he formed a group of persons, tried to grab the suit land, including other lands of the complainant illegally. Para 5, my lord, a third line from the top. Out of greed, formed a group of persons, tried to grab the suit land, including other lands on the complainant illegally by using force in the middle part of May 2015. But due to timely intervention by the case filed by the complainant under section 107, 144, 145 CRPC, and the Court of Executive Magistrate Gwalpara being case number so and so, they could neither enter the suit land nor succeed in threatening, and the said case was ended when the complainant continued to possess the land till 2016 peacefully. Now this date is very relevant. However, on the respondent accused person named above, who are again on from 2016 trying to dispossess the complainant from the suit land in question by causing wrongful threatening with dire consequences, and therefore he says that he filed this case. Now he says, my lord, there was a proceeding before the learned magistrate, my lord, executed under section 107, 144, and that proceeding ended on 2016, and thereafter we started again disturbing them, and therefore he filed this case. Now this case was incidentally filed on the next day itself. On 2016, this proceeding, 144 proceeding came to a close, and on the next day, he files a complaint alleging that we have been trying to dispossess him. Therefore, his case is that from 2016, the cause of action arose from 2016. Now, your lordship will find the complaint, it is filed page 15, date of filing. It was filed on 21/7/2016, the very next day. Now, on the other hand, my lord, the case of the, my lord, the petitioner before lordship, my lord, the accused, my lord, it is that, my lord, that Afazuddin Sheikh executed a will, my lord, on page 24, my lord, 3, in favor of respondent number 1 in presence of the witnesses and duly registered office of sub-register. Well, but unfortunately, my lord, I must admit, my lord, that this will was, my lord, perhaps not probated also, my lord, and there was no, my lord, no evidence was adduced to or exhibit. This will was exhibited, my lord. So, my lord, on that basis, my lord, the evidences were adduced. And before I read the evidence, my lord, may I come to the judgment, my lord? Then I'll come to the evidence, my lord. The judgment is page 41, my lord. That was decided on 26th of April 2022. The case was registered on the basis of complaint filed by the petitioner under section 4/5 of the Assam Land Grabbing Prohibition Act 2010, praying for taking cognizance of the land grabbing against the respondents. The plot measuring, the alleged plot of grabbed land measures about 3 bighas, 2 cut and 5 liches, according to Dag number so and so, and covered by so and so of village and of the Matia revenue circle. Then, my lord, he narrates his case, my lord, as my lord I have stated, my lord. In para 4, my lord, the respondent's case is, my lord, depicted, my lord. We had claimed that these deeds are forged and all, my lord. The respondent in brief alleged that the gift deeds by which the petitioner is claiming right over the suit land are all forged documents, which were executed by Azizul Rahman by way of impersonation. They've denied the original owner, Altafuzin Sheikh, had donated the suit land to Azizul Rahman or had executed any gift deed to the effect 1982. Rather, according to them, Altafuzin Sheikh had executed registered sale deed on so and so, bequeathing properties in favor of the respondent number 1, Abed Ali, who had also handed over the possession of the suit land so and so. Now, my lord, the following issues are framed at page, my lord, 44, my lord. Whether there is a cause of action, number 2, whether it is maintainable, in its present form and manner, whether the suit land was owned and possessed by Altazuddin Sheikh, and he gifted the suit land to Azizur Rahman by executing registered gift deed. When Azizur became being the owner and possessor of the suit and executed gift deed number so and so in favor of the complainant, whether the complainant had acquired right title and interest over the suit land through the gift deed. Respondents tried to grab the suit land on May 2015 to 27, 2016, and as such, they committed an offense under the provisions of so and so Act, liable to be punished under said law. Whether the complainant is entitled to any relief, to what extent other reliefs the parties are entitled to. Now, the petitioner examined 3 witnesses and examined 5 documents, exhibited 5 documents. We did not reduce any evidence, my lord. Then, my lord, the exhibits are, my lord, the exhibit 1 is the registered gift deed, but this is by the, my lord, complainant himself, my lord. Then the registered gift deed of 2007, my lord, Jamabandi copy, landholding certificate, land revenue paying certificate. Now, PW1, my lord, in this cross-examination deposed that the respondent is the elder brother with whom he has got a case under section 107-145 CRPC pending in the DC office, and he had applied for Jamabandi before the SDC, but he did not send any notice of mutation to the respondent. He has filed this case and has obtained a report from the court. As per the report, the said suit land is not in possession of any of them. So the report says, my lord, the suit land was not in possession of any of this, either the complainant or the, my lord, the petitioner before lordship, the accused person. He has denied that the deceased father had prepared the partition documents by preparing the name of his brother in the documents, and that he is only trying to take illegally over the possession of the suit land, which has fallen in the share of his elder brother. PW2 the attesting witness of exhibit 2, according to him, exhibit 2 so and so are signatures of the father-in-law, the donor Azizur Rahman. Exhibit 2, 10 and 11, his signatures therein as witness. During the cross-examination, PW2 has deposed that the suit land fell in the share of Altazuddin Sheikh, and the name of his eldest son, Boga, and Azizur Rahman, his father-in-law, had given it to the petitioner. He has denied that Boga is not the name of the elder son of Altazuddin, and that Abed Ali was gifted this land, and that Abed Ali, in his possession of the suit land, he did not grab the suit land. He is an advocate's clerk by profession of Gwalpara Court, and he has come to reduce evidence on behalf of the father-in-law. PW3 deposed that he is a scribe of Exhibit 2, and on 4/1/2007, the petitioner, along with Azizur Rahman, had come to the office of the sub-registrar Gwalpara and had requested him to write a gift deed, and accordingly, he had written Exhibit 2. It was duly executed by Azizur Rahman in his presence, and that of PW2 and Habiluddin. Further, PW3 has identified the signatures of donor Azizur Rahman as exhibit so and so, and that witness Habiluddin as exhibit number so and so, respectively. Further, exhibit number so and so are his signatures as scribe of the deed, and during cross-examination, PW3 deposed that he is the deed writer. He got a license which he has brought. The suit land is part of the Patta land. He is writing deeds since 5-7 years ago. Nowadays, photographs are required in sale deed, gift deed, and he did not himself witness the respondent Abed Ali disposes the petitioner from the suit land. So, he did not see that there was a dispossession, my lord. He does not know who is in possession of the suit land. He had merely put his signature in the evidence without reading its contents. So, my lord, this is very relevant. Discussions and hold the reasons thereof. I have heard the arguments and so and so parties. Issues number 1, 3, and 4, all these issues are taken together for discussion. And for the sake of convenience, and also they are interrelated in nature. The admitted position of the case is that Altazuddin Sheikh was the original owner and possession of the suit land. According to PW1, Altazuddin Sheikh had executed Exhibit 1 in favor of Azizur Rahman on 9/8/82. In this regard, the section 90 of the Evidence Act lays down as follows. But I'm not reading it, because on the presumption of 30-year-old document. It is apparent on the perusal of Exhibit 1 that it is a 30-year-old document and it has been produced from the proper custody. That is the person in whose favor it was executed. So the presumption under Section 90 Evidence Act applies, and the formal proof is not required to prove this document. In a similar circumstance, the Honorable Gauhati High Court in so and so held the execution of deed is presumed if the same is 30-year-old and there is no rebuttal evidence. Moreover, the fact that these are registered on a presumption under Section 114E Evidence Act can be drawn up that Exhibit 1 was duly executed by Altazuddin Sheikh and duly registered by the sub-registrar Gwalpara. On the contrary, the responsive failed to rebut such a presumption by adducing any evidence. Thus, I conclude that Exhibit 1 is a genuine document and can be relied upon. In other words, I hold that the suit land, while being owned and possessed by Muhammad Altazuddin Sheikh, was donated to Azizur Rahman by executive registered deed dated so and so. Further, the evidence of PW1 coupled with the recital of Exhibit 2 clearly establishes that Azizur had gifted the suit land to him. One of the witnesses of the deed is that PW2 has even corroborated the evidence of PW1 and is also contents of the Exhibit number 2. And the scribe PW3 has also corroborated PW1 in this regard. Thus, there are overwhelming evidence on record to establish that Exhibit 2 is a genuine document and was duly executed in favor of the petitioner. Further, the Exhibit 3, the certified copy of Jamabandi of the suit land of Patta number 70, clearly establishes that the petitioner is in possession of the suit land. It is established law that the land entries in the records of right. Jamabandi establishes possession in favor of the person whose name is so inserted. That apart, the contents of Exhibit 1-4 establishes the suit land stood in the name of the petitioner. The Circle Officer Matia Revenue Circle issued a landholder certificate on so-and-so in his favor. Lastly, contents of Exhibit 5 establishes that the petitioner is regularly paying revenue to the government. On the other hand, I've gone through the contents of report dated so-and-so submitted by the Circle Officer Matia Revenue Circle in this connection, where it is again emphasized the suit is currently recording the name of the petitioner as being cultivated by his adhere, Sontu Molo Hussain till 2015. Having gone through the cross-examination of PW1, I find the opposite parties have failed to rebut the oral evidences and other PWs, and there are also contents in this regard of the gift deeds. On the other hand, opposite parties failed to establish their own claim of the suit land by using any iota of evidence. Thus, I find that the petitioner has got a valid right and interest of the suit land which has duly been acquired from Azizur in the year 2007, who in turn inherited from the original owner Altawazin Sheikh in the year 1982. In other words, I hold that Azizur Rahman, being the owner and possessor of the suit land, had executed a registered gift deed on so-and-so in favor of the petitioner, and thus, this is how the petitioner has acquired valid title, right, and interest over the suit land through these gift deeds, Exhibit 1 and 2. On the other hand, even though the respondents had set up the plea that Azizuddin Sheikh had executed a registered sale deed so-and-so, bequeathing suit land to the respondent 1, Abed Ali and his father, and further handed over the possession of suit land since so-and-so, the respondent in possession of the suit land, they failed to exhibit any sale deed by which the property was bequeathed or the certified copy of the Jamabandi showing the possession of the suit land. Otherwise, I can conclude that there is a cause of action for the case. The issues are accordingly affirmative and decided in favor of the petitioner. Now, issue number 2, 6, and 7. PW1 has specifically stated that the respondents, without having title, right, title, and interest, or possession of the suit land, has tried to illegally occupy the suit land in the month of May 2015, and so he had filed case number 1915 under section 107, 144, 145 CRPC before the Court of Executive Magistrate Gwalpara, due to which the respondents could not enter the suit land. Further, he has deposed that on 27/2016, the respondents again tried to dispose him, also threatened to occupy the suit land by exercising muscle power, and also tried to plow the suit land with tractor, and as a result, he could not cultivate the said land during the crop season, causing substantial losses to him. Thus, according to PW1, the respondents are threatening to sell the property to the suit land to a third party. At this juncture, it is worthwhile to point out that the report dated 28/2017 of the Circle Officer Matia, which I have taken judicial notice, that the revenue staffs on spot verification found on spot verification the suit land was lying vacant, and since 2015, and nobody was in possession. Thus, I could conclude the respondents have interfered with the peaceful possession of the petition over the suit land since in the year 2007. In other words, the respondents who are trying to dispose the petitioner from the suit land for which they are liable to be labeled as land grabbers. This is what I'm basically agreed with, Lord Mallard. Further, having scanned the materials on record, I found that the respondents have failed to establish by additional causal materials as to how the suit is not maintainable. Thus, these issues stand answered in affirmative when deciding against the respondents. Issue number 8, in view of the decisions of the foregoing issues, I am of the opinion the petitioner is entitled relief as prayed for. The issue is accordingly affirmative, answered in affirmative and decided in favor of the petitioner. The petitioner succeeds to prove his claim of the suit land described in the schedule of the complaint petition. The respondents are found to be land grabbers as defined in Section 2 of the Act, and they are liable to be prosecuted for commission of offences in Section 4 of the Act. Further, the petitioner shall be put in possession of the suit land after expiry of the appeal period. That the petitioner shall be compensated by the respondents for illegal possession of the scheduled land since year 2007, which is quantified at 1 lakh. In the failure to respondents pay, it shall be recovered from them as land area of land revenue. Prepare decree accordingly. Malad, my humble submission is, Malad, that first of all, Malad, so far as, Malad, the right and interest of the complaint is concerned, Malad, we have actually, Malad, we're not in a position to rebut that, Malad. But so far as, Malad, this disposition part is concerned, Malad, this is something, Malad, just based on surmises and conjectures, Malad. And, Malad, the other PWs have not been supported. Their Malad, version is hearsay, Malad. I'll read the evidences, Malad. The, Malad, evidence I have also annexed, Malad, here. The PW1, my lord, is the complainant himself, my lord, who had adduced evidence. My lord, his evidence, my lord, in chief is page 28, my lord. Where he has basically, my lord, narrated, my lord, what has, my lord, he has said in the plaint, or my lord, his petition, that he got this, my lord, from, first of all, Altawuddin Sheikh, my lord, gifted this land to, my lord, Azizur Rahman. Then Azizur Rahman gifted it to him in 2007. And then, my lord, he, as he said, my lord, he said that in May 2015, they tried to, my lord, grab the suit land. And, my lord, for that, he filed a case with the executive magistrate. And then they could neither, but then they neither could enter the suit land or, my lord, nor could succeed in threatening the case of the, my lord, which ended on 27/2016. So, my lord, therefore, my lord, he himself says, my lord, that though there was some attempt, my lord, they could not enter, and there is no disposition for the suit land. Paragraph 6, my lord, page 29. That I say that suddenly in the middle part of May 2015, the respondents, out of greed, formed a group of persons, tried to grab the suit land, including my other land, illegally by using force, but due to timely intervention by filing case under so-and-so before the Court of Executive Magistrate Gwalpara, they could neither enter the suit patta and dag of the land, nor could succeed in threatening, and the said case was ended on 27/2016, when he was in physical possession of the land grab. So, my lord, he admits that he was in physical possession of the land. However, the respondents who were again on and from 27/2016 trying to dispossess me for the suit land by causing unlawful threatening and with dire consequences on the strength of their muscle power, and trying to plow the suit land by the tractor and apprehending me to not to plow and cultivate the suit land. It is in the ongoing small sali crop season, resulting to substantial irreparable loss and substantial damage to me. So his claim of damage, my lordship will see, he said that this case ended on 27/2016, and the next day he files a case. So this entire story is concocted, that he was prevented, my lord, that they were trying to, my lord, stop him from cultivating, because the day before the case ended, the next day he filed this case, my lord, just to make it continue, my lord. And he says, my lord, there was no, my lord, disposition, my lord. Then, my lord, I will skip the rest part, my lord. That will be relevant, because these are, my lord, this cross-examination, my lord. Page 33. Translated part, my lord. Now, the complainant are 4 brothers. I know the name of all. The disputed land stands in the name of Altawuddin. As I know, and as I know, the name of my elder son of Altawuddin is Boga. It is not a fact the name of elder son is not Boga. My father-in-law Azizur Rahman gave the land to the complainant. It is not a fact that the disputed land is gifted by the respondent Abed Ali. It is not a fact that Abad Ali is in possession of the land. Now, Abad Ali is the petitioner before lordship. Hence, he did not take possession of the land. I have come to depose. Sorry, Miller, I made a mistake, Miller. This is the evidence of respondent number 2, Miller. Sorry, I made a mistake, Miller. The PW1's evidence,
number 27.
Page number 27, Miller. Respondent is my elder brother, own elder brother. It is not a fact that my deceased father partitioned the land of my elder brother by preparing a paper. This is a case under section 104/145 in the office of the DC between me and the respondent. I saw Jamabandi from the DC. As DC, he did not send the notice of mutation. I have filed the LG case. Report was submitted in the court. As per the report, both of them do not have the possession. It is not a fact that I have filed this false case to illegally occupy the share of my land of my elder brother. It is not a fact that on 27/2016, the respondent along with the men came and threatened to dispossess me. It is not a fact that I'm not entitled to get any relief in this case, LG case. It is not a fact that Azizur did not give it to me, and I did not give it to Azizur. It is not a fact that deed of Azizur is fake and Azizur did not make the deed. It is not a fact that my father did not give it to Azizur. It is not a fact that I filed this case only to harass my respondent brother. Now, Mala PW2, Mala. His cross-examination, just reading, Mala. He said that the complainant are 4 brothers. I know the name of all of them. The disputed land stains the name of so-and-so. As I know the name of eldest son of Abdul Altafuddin is Boga, it is not a fact that the name of the eldest son is not Boga. My father-in-law Azizur Rahman gave the land to the complainant. It is not a fact that this disputed land is gifted by the respondent Abad Ali. It is not a fact that Abad Ali is in possession of the land, and hence he did not take possession of the land. I have come to depose in favor of my father-in-law. I am a Mohri in the Gwalpara court. It is not a fact that the complainant did not give any kind of possession prior to 6 months. It is not a fact that I have falsely deposed in favor of my father-in-law. Now, my lord, in his evidence, my lord, in chief, my lord, para 35, page 35, my lord, para 5. Because mainly I am on the possession part, my lord, because whether there was actually, my lord, any proof of, my lord, disposition or, my lord, attempt of disposition. That is what I'm on, because other part, my lord, since it was not, my lord, nothing could be, my lord, exhibited or rebutted, my lord. So far the gifts are concerned, my lord. So that I'm not, I mean, agitating, my lord, because my case, my lord, unfortunately, that was not done, my lord. Now, my lord, that I heard that this is evidence, my lord. It is a hearsay evidence that I heard that the respondents in several times tried to grab the suit land by using force but failed. But the respondents were found to search for probable purchaser to sell the suit land for the personal wrongful gain. In doing so, responsive committed the offense under so and so. So he has only heard that he was trying to grab the suit land and that he was trying to search the for probable purchasers. Then, my lord, PW3, he is a witness to this deed, my lord. His examination chief is at page annexure 5, my lord. Page 39, my lord. He is also saying the same thing. I have heard from the complainant that the respondents in several times tried to grab the suit land illegally and by using force but failed. Besides, the respondents were found to such probable purchasers in the suit land for their personal wrongful gain. In doing so, the responsive committed offence under section the provisions of section of the Assam Land Grabbing Act 2010. So basically, my lord, his evidence is also hearsay, my lord. And then, my lord, in his cross-examination, he says, page 37, I am the witness of the deed. I have a license. I have brought it today. It was a patta land. 6-7 years back, the deed was written. Nowadays, the photographs of donor or sellers are attached with the deed. I have not seen the respondent Abad Ali illegally occupied the disputed land. I do not know who is in possession there. I have not read the evidence in affidavit. Only I signed it. So he says that he doesn't know what is there in the affidavit. He just signed it. It is not a fact that I know the dispute land. I do not know the disputed land and I know nothing. It is not a fact that I have deposed falsely. So he's trying to say that he has not deposed falsely and he knows about the disputed land. And then he says that he has not seen anyone Abad Ali possessing the suit land. So therefore, my lord, except for this, my lord, statement, then in May 2015, my lord, they had tried the petitioner tried to grab the land, my lord. In fact, this order of the learned court, my lord, on 107 proceeding, that was not executed for the learned court, my lord. So, in fact, it said, my lord, that there's a case, but it doesn't say whether there is a stay order also. In his evidence or in his petition, it doesn't say that there was a stay order because of which we were prevented or we could not take possession. He said there was a case and therefore we did not enter in the suit land. And his next case is that thereafter, when the case ended, the 107 proceeding ended, we started trying to dispose him. But it's the next day he files this case. So there is
No, is there any bar in filing the suit on the
there-
very next day?
no, there is no
If
bar.
somebody tried to
Yeah.
grab the land, then-
Yes, no, true. There's no bar.
Yeah.
But he says that from
No, you were emphasizing on that point
no,
repeatedly.
no, I'm trying to emphasize on that point because of the fact, my lord,
Mm.
that first of all, his case is that they've been trying to dispossess me from 27.
Mm.
Then 21, 20 next day.
Mm.
And he files the case on the next day. Therefore, it was just, after this case ended, it was only with an intention to, my lord, file this case that, or to prevent him from, my lord, any, my lord, dispute being going between them, my lord. This was, my lord, this illegal possession story was made out, my lord. That is what I'm trying to say, my lord. And lordship will see, my lord, none of the petitioners, none of the, my lord, respondents witness, petitioners witness, my lord, complainants witness, well, corroborated the fact. They said that no one is in possession. The circle officer's report says no one is in possession. My lord, basically that's why I'm on, my lord, is that 1 lakh which has been, my lord, quantified as a compensation for illegal possession. Because otherwise, my lord, I understand, my lord, this, my lord,
No, if no one is in possession of the land,
my lord.
then according to you, this imposing of rupees 1 lakh
Yes,
as
my lord.
compensation is illegal.
Illegal. That is one part of the story, my lord. Because otherwise, my lord, the court has come to similar finding, my lord, that the petitioner, the respondents are found to be land grabbers and they are liable to prosecuted for commission of offences, section 4. Shall be put into possession of the suit land of expired appeal. I'm not on that, my lord. That the petitioner shall be compensated by the respondents for illegal possession of the suit land for the last 7 years.
Mm.
So he has quantified, my lord, this 1 lakh, saying that I've been in possession for the last 7 years. Whereas there is no proof that there is no proof that I took possession. In fact, it is to the contrary. Even, my lord, there is nothing to suggest that I tried to grab the land, except for, my lord, the statements of the PW1 or the complainant. The other PWs do not support his contention that, in fact, there was a land grabbing attempt by me. So, my lord, under the Act, my lord, attempt to land grabbing can also be an offense. So, therefore, what my submission is, my lord, that there is no evidence at all, no corroboration from any of the witnesses saying that there was some attempt in 2015 to take over the land, first of all. Secondly, my lord, both the PWs have contradicted the statement of the petitioner or the complainant that he was dispossessed or there was an attempt to dispossess. In their hearsay evidence, they said they heard that the petitioner before lordship was trying to dispossess him, but this is hearsay evidence only. And the learned court, my lord, imposed a punishment of 1 lakh, saying that I have been in illegal possession for the last 7 years, my lord. That is what I'm basically aggrieved, my lord. Because other parts, my lord, I cannot challenge because the deed has been, my lord, proved, my lord, there. I have not challenged that, my lord. I did not reduce any evidence. So I have to, my lord, rely on whatever, my lord, the records reveal. The witnesses of the PW, my lord, it is ultimately the PW has to establish the foundational facts. The petitioner has to establish the foundational facts. So that those foundational facts of dispossession or attempt to dispossession was not at all even prima facie established. Rather, to the contrary, the witnesses have been saying that no one was in possession and we have never seen anyone in possession. We only heard that they were trying to dispossess. And the circle officer's report is also very clear. It says no one is in possession. So this compensation of 7 lakhs, my lord, that part, my lord, is totally perverse, my lord. How this learned court came to the conclusion, my lord, that, my lord, that part, my lord, it's totally based on surmises and conjectures, my lord. Because he is trying to claim, my lord, because of this, my lord, he was prevented from, my lord, cultivating. That is not established, my lord. And page 20, paragraph 23, he takes judicial notice of what the circle officer's report says, my lord. He says that nobody was in possession. Thus, I come to the respondents have interfered. At this juncture, page 51, it is worthwhile to point out from the report dated 28/2017 of the circle officer Matia, of which I have taken judicial notice, the revenue staffs have found on spot verification the suit land was lying vacant since the year 2015 and nobody was in possession. Thus, I conclude that the respondents have interfered with the peaceful possession of the respondent number 7 of the suit land since the last 7 years. So totally contrary finding, madam. In other words, it is the respondents who are trying to dispossess the petitioner from the suit land for which they are liable to be labeled as land grabbers. My lord, even that part, my lord, is not corroborated by that in 2015 there was an attempt, my lord. He has not even exhibited that order of the learned court, my lord, under 107 proceeding, my lord, where there was a finding against me. So therefore, this entire story of dispossession, my lord, he might have been able to prove his, my lord, right title interest over the suit land, my lord. That I cannot dispute perhaps at this stage because of, my lord, the lapses or whatever, for whatever reason, my lord. We did not deduce any evidence.
Mr. Dotto, you say in the definition clause, the word used is occupy, not possession.
Pardon, my lord?
The word used is occupy
My
or
lord.
attempt to occupy.
Yes, my lord.
Not emphasize upon the possession here.
True, my lord. True. That's what I'm saying, my lord. Even an attempt can be land grabbing. But what is the evidence on that attempt, my lord? Except for the PW1 saying that in 2015, they were trying to dispossess me, or from 2020, from 27, 2026, they were trying to dispose us, whereas he files a case on the next day. Where is that, my lord, span of time, or where is that event, my lord, by which disposition was, my lord, established, or, my lord, the attempt was established, rather? The other, my lord, witnesses said, we heard that the respondent was trying to dispossess them. This is hearsay evidence.
From whom they heard about the same?
One says from the complainant.
Okay.
One of PW3 says from the complainant, but the other says I heard. He doesn't say, he doesn't specify. My lord, Lordship will see, my lord, page 35. This is the PW. This is sorry, my PW2 says I heard from the respond. I heard that the respondents in several times tried to grab the suit land by using force but failed. But from whom he heard, he has not stated. But PW3 says in page 39. I heard from the complainant that the respondents in several times tried to grab the suit land illegally by using force but failed. They also do not, my lord, say that in 2015. When they heard, how they heard, from whom they heard, nothing is there. They did not say that we heard in 2015 that there was in 2015 there was some kind of disposition attempt. That is also not there. Except for the statement of the PW1 in his petition and in his evidence, he said that in the middle part of May 2015, there was an attempt to dispose us. That much only. Therefore, my lord, what I'm trying to say, my lord, that this entire story of attempted disposition, my lord, has not been proved.
No, in the middle part of
May
of
2015, my lord, para 6, page 29.
when the case was filed?
Case was filed in 2016, my lord.
16.
Case was filed after they say, my lord, the 107 proceeding ended. So he initially filed, my lord, proceeding under 107. That, my lord, document is not exhibited. That order of the learned magistrate, that in order, page 6, my lord. Sorry, page 29, para 6. That I say that suddenly in the middle part of May 2015, the respondents out of greed formed a group of persons trying to grab the suit land, including my other lands illegally by using force. But due to timely intervention by filing case under section 107, 144, 145 of the CRPC before the Court of Executive Magistrate Gwalpara, being case number 1915, they could neither enter the suit land of the Dag land nor could succeed in threatening. And the said case was ended on 27, 2016 when he was in physical possession of the land grab. However, the respondents who were again on and from 27, 2016 trying to dispossess me from the suit land by causing unlawful threatening and with dire consequence on the strength of their muscle power and trying to plow the suit land by tractor and apprehending me not to plow and cultivate the suit land in the ongoing Sali crop season, resulting in irreparable loss and substantial damage to me. So, my lord, his case is that in May 2015, there was an attempt to dispossess. And therefore, he filed this case under 107, which ended on 27, 2016.
So, do you have the copy of that 107 proceeding?
That, my lord, I also do not have, my lord, because he is also not exhibited in the case, my lord. This is not a part of his exhibit, my lord, of the my lord, complainant, my lord. It was his duty, my lord, to exhibit this document, my lord. He did not.
Do you have the copy of the document?
Okay, I don't have.
Do not have.
That was not a part of the exhibit, my lord. He didn't exhibit. So, my lord, therefore, my lord, my entire, my lord, contention in this case is based on the, my lord, disposition part. I cannot, my lord, agitate on the other part, my lord, because of, my lord, the way the case was conducted, or, my lord, for might have been, my lord, there was no evidence at all. But the fact remains is that, so far the disposition part is concerned, my lord, the plaintiff, or rather the petitioner, the complainant, failed, my lord, to show anything, my lord, that there was actually an attempt of disposition.
No, that disposition was the bone of contention in the proceeding under 107.
Yes. That was under 107, but that 107, nothing has been brought on record. What happened?
Can I call for the record from the That may be available in the executive magistrate court.
That may be, that has then, that record has been called for, my lord, from that court, my lord. That is, case
Mr.
19 and 15,
Gogoi,
my lord.
are you appearing here?
Lords.
Whether but this 107 proceeding can be called for from the Court of Executive Magistrate, Golpara. Page number 29, paragraph number 6.
Case number 19 and 15, executive magistrate Gwalpara. The learned court also did not call for that record, my lord.
Or can you produce it?
Right now, I am not able to.
No, not right now. Will give you some time
Yes.
in the next week then? We will keep the matter as part of, you produce the record of that 107 proceeding?
My lord,
Yes.
as your lordship pleases, my lord.
Heard, Mr. M. Dotto, learned counsel for the petitioner, Mr. S.C. Sharma, learned senior counsel for the respondent number. Respondent number? Respondent number 4A. 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 Mr. Gogoi for respondent number 123. 23. Mr. S. Dotto, learned counsel for the respondent number 1. During the course of hearing, Mr. Dotto, learned counsel for the petitioner, has pointed out that the respondent hearing, respondent number 4A hearing, has instituted one proceeding under section 107, 144, 145 CRPC, being case number 99 of 2015 before the Court of Learned Executive Magistrate Gwalpara. Gwalpara 4.
My lord, which was perhaps disposed on 27 2016 as per this, my lord.
For attempting to grab the suit land in the middle part of May 2015 by the petitioner hearing. Mr. Dotto also pointed out that the proceeding of the said said case number 99 of 2015 has not been enclosed with this petition. And in that view of the matter, it is provided that Mr. Gogoi, learned government advocate appearing for the respondent number 2 and 3, is directed to produce the copy of the aforementioned record from the Court of Learned Executive Magistrate on next date. List the matter on next date, on next week. Short date. Eight. Court may call it. Yes, sir. Court may
Can it be, my lord, on a hearing day, my lord, on 14th, my lord, 19th May, my lord?
election of ব্যস্ত থাকিব ন? No, Mr. Dotto, this is admission matter,
My lord.
so we'll
My
fix
lord.
it on 14th of May then.
14th of May.
14th of May. This is the list the matter is parted.
Well, 14th some difficulties, my lord. Then let it be 15th, my lord.
15. Okay, 15.
My lord.
Number 5.
May I please, your lordship? Lordship, the accident occurred on 22/8/2021. And the new limitation under section 166(3) of the Motor Vehicles Act came into force with effect from 1/4/2022.
Yes. Where is the impugned order?
Impugned order is at page number 14, your lordship.
Hmm. So why we have adjourned the matter on the other day?
The respondent number 2 said that 2 and 3 said they did not receive copy.
Okay, okay.
I've already handed them the copy.
Okay. So, Mr. Goswami, the accident took place before the amendment. So they will be governed by the earlier act. So this question of limitation does not arise.
Both of a similar CRP in the case of Jitumoni Saloi versus United India.
Hmm.
Similar, I could not get the citation in the court.
Hmm.
So people reported in ACG accidentally in the matter.
Hmm.
In that case, the similar CRP was allowed by your docs.
Do you have the copy of that order?
Lordship, is that it's not available in our library. I have to bring the book tomorrow.
It is in your
Next
book.
week I'll bring the book.
Can you give the number? We can
I have the name only Jitumoni Saloi versus United India.
Jitumoni Saloi versus United.
You know, so that's exactly on
Does.
the left. United. With allowed by the
So we can allow this petition then. Okay, we are disposing of this petition then.
I need to provide the citation in the
Yes, we can find it. Okay. Okay.
A batch of similar petitions was also disposed of by Honorable Devashish Bhagwan. In the same lines, allowing all petitions.
Okay. Okay. Awesome. Okay, we are disposing of the matter and remanding it to the learned trial court.
Obliged, your lordship.
Item number 6.
Yes.
May I please, Your Lordship?
Hmm.
Whether this revision petition is filed against the order passed by the executing court in title execution case number 1 of title execution case number 4 of 2011. Whether the hmm?
Okay. The execution case was filed after 27 years.
27 years.
Okay.
Whether that decree was passed for the uh, injunction,
Mm.
declaration of title and injunction.
Mm.
So the injunction part, there is no time bar as an article part 36.
Mm.
The injunction can be executed or can be case can be filed. So far the recovery of possession is concerned,
Mm.
that part cannot after 12 years.
Mm.
And that is our the whole case.
Okay.
The case of the present petitioner is this, madam. Originally the defendant, uh, they filed a suit
Mm.
in the court of Munsif, Gwalpara,
Mm.
title suit 94 of 79. That is page 20.
Yes.
That is the plaintiff, one Insan Ali, and the defendant is government, Naib Ali, Siraj Mandal, Iman Ali, Siraj Mandal, Umar Ali, son of Siraj Ali, Umar Ali, son of Siraj. All are sons of Siraj. This suit was filed praying for this suit was filed by the plaintiff, the right title interest, interest and for permanent injunction. The prior portion is at page 25. A decree, a decree declaring that the plaintiff has right title interest over the suit land, decree for permanent injunction restraining the defendant number 227 from dispossessing the plaintiff from the suit land. If the defendant disposes the plaintiff from the suit land or any part thereof, or construct house or other structures thereon during the pendency of the suit, then decree for cash possession will be passed. A decree for considering the pro forma defendant as principal defendant if they submit written statement against the interest of the plaintiff. Full cost of the suit. But here in this case, here the prior you will also see construct the if the defendant disposes the plaintiff from the suit land or any part thereof and construct a house thereon, dependency of the suit, then the decree for cash possession will be passed. And this suit was contested by the by the defendant number 1. And his written statement is, not annexed, and his judgment passed. And his judgment passed by the trial court. It starts from page 35. Oh, sorry. Sorry, their prayer is by the Prohibitions. Is 41. The judgment of the suit starts from page 35.
Hmm.
And in that suit, the suit of the plaintiff was decreed. And in that case, my lord, some issues were framed as page 37. Whether plaintiff has cause of action, whether there is a cause of action for the suit, whether notice under section 80, whether the suit is barred by limitation, whether suit is undervalued, whether the suit has been wrongly recorded as cash by the SDC, whether the plaintiff has right title interest over the suit land, whether the plaintiff is entitled to get relief as breakthrough. And the decree that was passed, the operative part of the judgment at page 41.
Hmm.
It is ordered that the plaintiff in the suit then hereby declared. Right title interest of the plaintiffs declared.
Declared. Hmm.
It is also ordered that the permanent injunction be issued against the defendant number 2, 3, 4, 5, 6, and 7, not to disturb the possession of the suit land in any manner. It is ordered that the suit of the plaintiff is decreed on contest against the defendant number 1 and ex parte against the other defendants without cost, ordered accordingly. Here, my lord, your lordship can see their priority plaintiff is for the recovery of possession.
No, that was not decreed.
That was not decreed. That the decree, declaration of right title interest and
And
injunction,
permanent injunction.
permanent injunction.
Hmm.
Recovery of possession was not decreed.
Hmm.
These, when the suit is pending, they have not filed any exhibition case. In the meantime, the defendant filed a title suit. That is in page 51. Title suit number 24 of 2003.
Title suit number,
24 of 2003.
page number
Page number 51.
51. Okay.
Here, my lord, we have made the plaintiff of that suit
Hmm.
in this in my suit, and we prayed and the prayer of our suit is at page 59.
Yes.
A decree for declaration the plaintiffs have acquired the right title interest over the suit land on the strength of long adverse possession for more than 40 years. Prayer number 1. Prayer number 2, for a decree for declaration that the judgment passed in 12/4/1984 and the decree prepared on 18/4/84 on 94 of 79, that the earlier suits, as obtained fraudulently, and the same was void ab initio and liable to be set aside. decree for perpetual and temporary injunction restraining the defendants from their man, woman, from entering into the suit land and from disturbing the possession of the plaintiff. Suit for perpetual and temporary injunction of the land in the fictitious name of Insan Ali, basing on the fraudulent and void decree of TS 94 of 1979. Decree for mandatory injunction directing the defendant number 1 to grant a recorded patent. Here, my lord, in the subsequent set that we have filed, we have filed the suit that we are in long possession. And we got the right over the land by adverse possession. And secondly, the decree, the decree passed in earlier suit 94 of 79 is fraudulent. These are the two main players in our suit. The learned trial court. Yes. 72. The learned trial court passed the judgment by the at page 72 and Annexure 4. Page 80, issues. Whether there is cause of action for the suit, whether suit is maintainable in the present form, whether suit land was recorded as a has on 16/3/66, whether the plaintiffs have been possessing the suit land for since 40 years along with the predecessor of the inside interest, predecessor interest Imanali, and they have acquired the right title interest to the suit land by adverse person, whether the suit is bad for non-gender of necessary parties, whether the defendant number 1, Maulana Fazal Haq and Isan Ali are the same person, whether the judgment in title suit number 94 of 79 obtained by the defendant number 1 in the name of Isan Ali are fraudulent, void, and same are liable to be set aside, and whether the plaintiffs are entitled to the relief claim for. There is a counterclaim. On the counterclaim, the following is the claim. Whether the counterclaim is devoid of any cause of action, whether counterclaim is maintainable, whether the sale deed number 3439 dated so and so is void, whether the decree obtained in title suit number 94 of 79 is barred by limitation is fraudulent one. And the learned trial court at page 84, issue number 4. Whether the plaintiffs have been possessing the land since 40 years, because I have claimed the right over my land by adverse possession. That is the issue number 4. Whether the land has been possessing, whether the plaintiff has been possessing the suit land since 40 years along with their predecessor in interest Umar Ali and have acquired title by adverse person. In this regard, I would like to discuss the evidence of DW1 has admitted in the cross-examination that he had not put any Tozibahi Khazana of the suit land. He admitted that the plaintiffs are possessing the suit land by construction of dwelling house on a part. He admitted that the Umar Ali predecessor of the plaintiff name has been recorded as the record of as possessor of the original with his name. Exhibit 11 is the relevant entry showing the name of Umar Ali. Tag number so and so. Exhibit 11.5 relevant entry in the name of Umar Ali. Both tag 1 128 and 29 are the khas pertaining to Khatian number 2 of the original owner is recorded from the above land of the Morali. So I find that the plaintiff have been plaintiff have been established that further oral evidence of PW1 to PW7, the dispute land has been possessing the plaintiff side. I note the evidence of DW2, who had stated in the cross-examination that suit land is a patta land and is not a khas land. In brief, a major discrepancies of the evidence of DW1, defendant number 1. As such, as such, based on the evidence and document exhibited, I find that the plaintiff side has been in continuous possession of the suit land, including the schedule of the plain since 1960, and have acquired the title by adverse possession. As such, the issue is decided in favor of the plaintiff.
So ultimately that decree was set aside. Earlier decree was.
Hardly what the decree was set aside.
Hmm.
Earlier decree was set aside. Uh, they preferred an appeal.
Appeal.
Yes.
What was the outcome of the appeal?
Outcome of the appeal, my lord, the title, they have the our right by adverse possession is confirmed, and they can only get a right to permanent injunction.
Where is that order of the appellate court?
Issue number 6 and 7 was set aside and other issues were not accepted. That the fictitious person by the insanity that was also set aside and the judgment is binding upon them, that was.
Where is that finding? Oh, appellate court?
Issue number 142.
My lord, the page number, you will get a chance because the
Yes,
frequent interruption is not a proper practice,
yes.
and the advocate should maintain a normal decorum.
Finding of the appellate court is at page number?
Appellate court's judgment at page 138.
138.
Judgment is a judgment starts from page 118. And so far my relevant portion is concerned, it's a very long judgment. Page number 118 is the judgment passed in appeal. And the relevant portion is, your lordship kindly turn to page 138. The learned counsel for the appellant defendant submits that in view of the decree passed in 94 of 79, which is binding on the Omar Ali, and accordingly on his successors, the present plaintiff respondents are not entitled to getting the declaration of title in respect of the same suit land. And accordingly, and according to 136 limitation 8, there is no limit to executive purposeful injunction. That is the finding of the appellate court. Huh? That is. Thereafter, my lord, they come to page 141, paragraph number 16. Thus, after having regard to the aforesaid judicial authority as adduced above, it is seen that the instant suit of the plaintiff are able to establish that they are possessing the suit land since 1960 by Omar Ali, the predecessor in interest of the plaintiff respondent, and after his death, the present plaintiff respondent stepped into the shoes of the possession of the and the same while there is nothing in the hand of the appellant to show that they are possessing the suit land at any time. Though the decree for perpetual injunction was passed in favor of them in respect of the suit land, and the decree has yet to be executed, it cannot interrupt the adverse position of the plaintiff respondent over the suit land. The aforesaid decree was said to be passed during the year 1984. Until then, long 21 years have been elapsed, and the defendant cannot show anything that the plaintiff was disposed of the suit land by the defendant of his own suit on the strength of the decree. Hence, the appellant got the title extinguishes by virtue of adverse possession by the plaintiff respondent who claimed that the land hold the suit land is adversely to the defendant and the other person. Hence, it is seen that the plaintiff is entitled to a decree for declaration of title and permanent injunction. Now, after reading the impugned judgment, it is seen that the court below was settled in many issues. Regarding the issue number 1, 2, 3, 4, 5, 7, and 8 and 9, the issues of the counterclaim and the learned trial judge decided the above issues in favor of the plaintiff respondents are careful consideration of the evidence on record and the proper appreciation of law and fact. I have nothing to interfere with the decision of the aforesaid disease. However, the issue number 6, whether the defendant Maulana Fazal Haq and Insan Ali is the same person, and the issue number 7, whether the judgment and the decree of 94 obtained by the defendant number 1 in the name of Insan Ali are fraudulent void in the manner and are liable to be set aside. It is seen that the learned judge also decided the issues informative and and in favor of the plaintiff. In this connection, I have said that the evidence there is nothing to show that the defendant number 1, Maulana Fazal Ali, and Insan Ali is not the same person. A person's name may be dual in both the cases. It is seen that the father of the name are same. It is not established that the Maulana Fazal Haq is different from the Insan Ali. Therefore, Lordship may skip and to page 143, paragraph number 17. In the result, the appeal is allowed on contest. The decision of the trial judge on issue number 6 and 7 are hereby set aside. Regarding the issue number 1, 2, 3, 4, 5, 8 and 9. 8 and 9, I have seen there is nothing illegality committed by the trial judge and the aforesaid. Hence, the impugned judgment and decree dated 31/12/94 passed by civil judge number 1 Gauhati date 24 is hereby affirmed with following modification. The relief regarding of declaration that the judgment passed on 12/4/1984 and the decree prepared in 18/4/84 in title suit 94 of 79 are obtained fraudulently and as such liable to be set aside. Being void ab initio will not operative and hereby set aside. The trial court held that the decree was obtained fraudulently. Decree of title suit 94 was fraudulently and that was reversed by the appellate court. The next paragraph. All other reliefs given in the impugned judgment are hereby affirmed. The parties are left to their own cause prepare the decree. Here the all other reliefs including uh, all the including that I got the title over the land by long possession, by adverse possession. That decree was upheld by the appellate court. Therefore, I got the title over the land. That is, my title is proper. I got the mutation and everything is there. Hereafter, my lord, the respondent, they filed the execution case. Execution petition. They filed the execution case at page 163. And the relief prayed in the petition, your lordship. Point 10. Come to the point number 10, page 164, point number 10 below. I pray that the notice be served upon the defendant number 2, 3, 4, 5, 6, and 7, stating that the matter in possession, a matter of possession and injunction restraining them, their man, woman, servant, etc., from distributing, from disturbing the plaintiff decree holder in possession of the suit land and in any manner and in disobedience with the said order, they may be detained in the civil prison or the property be attached. Further, the cost of rupees 5,000 be realized. My objection and my grievance is this. Earlier suit, in the subsequent suit, I got the title over the land. In the earlier suit, they got the right title interest and the possession was not granted. Here in the suit, execution petition, they prayed for possession and accordingly writ was issued to dispossess us. Decree order of page 41, order of the page 41, that is order passed by the Munshi. It is ordered that the title of the plaintiff is hereby declared. It is also that the permanent injunction be issued as the defendant number 3 for not to disturb the possession in any manner. It is ordered that the suit of the plaintiff is decreed contest on defendant number 1 ex parte against defendant number 2. Confirmation of possession by recovery possession parent asset. Therefore, in their plain there is no prayer for confirmation of possession or recovery of possession. If there is no prayer for recovery of possession in the plaint, whether the executing court can issue writ to recover the possession of the suit land. And moreover, on the same plot of land, I got a decree in the subsequent suit which, by adverse person. And they preferred an appeal against the said decree. And that decree, my decree was upheld by the appellate court. Therefore, my whole grievance is this, that the writ of possession issued to me for recovery of possession is not maintained. And that the scanned copy of the record has come, my lord. The writ of possession
Okay, we will resume after 5 minutes.
I am referring to page number 164.
Mhm.
That is the prayer made in the
Writ.
execution petition.
Mm.
And then the
Execution petition.
execution petition,
And on the basis of this prayer, writ was issued.
yes. And when the scan copy of the record has come,
Mm.
I have also copy of copy this.
Mm.
That a flag Maharaj.
Mm. Okay.
My lord, the in the said rate, my lord,
Mm.
it is here to the bailiff of the court.
Mm.
Whereas the mentioned property
Mm.
described below in occupation of the above noted judgment letter, their man, woman, as an workman has been decreed to Ishan Ali of title suit number 94 of 79. You are hereby directed to put the said Ishan Ali, the plaintiff, the plaintiff decree holder in possession of the same, and authorized to remove the above named judgment debtors. They are men, women who are found in occupation under the under mentioned property by demolishing and removing all structural houses, trees, and customs from the suit land described in the schedule below to be identified by the plaintiff, the holder. You are further authorized to remove these judgment debtors or upon the lock or bell or break upon the lock, break upon any door or do any work is necessary putting the decree holder or his man, woman, etc. in possession of the property. Therefore, this is the writ issued in earlier case of 94,
Mm.
and writ was only the injunction was granted, not for the recovery of possession. And this writ was issued for the recovery of possession.
No, in the pair portion of the plaint, it is mentioned about the degree of possession. Page number 26.
No, but decree was not granted for
Mm.
possession.
No, this pair is conditional. Conditional in the sense that if the defendants disposes the plaintiff from the suit land or any part of it and construct house and other structures thereon during the pendency of the suit, then a decree for cast position to the plaintiff by demolishing such house and structures. Pair is there.
Prayer is there.
Hmm.
But that prayer was not granted by the court. As a judgment, your lordship kindly see.
No, here, this page number 41, order not to disturb the possession of the plaintiff. That means he was not dispossessed.
No, my lord, the 41
You
not,
see the order, 41,
yes,
page 41.
not to disturb the possession of the plaintiff from the suit land.
Mm.
That was the decree passed in title suit number 94 of 1979.
Mm.
Thereafter, I filed a suit.
Mm.
I filed a suit that is title suit number That is the title suit number.
Hmm.
Into 2003, we have filed a title suit.
Mm.
24 of 2003.
Hmm.
That judgment your lordship will get
Hmm.
page 89.
Hmm.
No, that is the
Hmm.
judgment of what? Page 89, your lordship.
Hmm.
Page 89.
Hmm.
That is the page 89. We have filed a suit,
Hmm.
title suit number 2003,
Mhm.
praying for declaration of right title interest
Hmm.
by adverse person
Hmm.
of the same plot of land.
Hmm.
Of the same plot of land. Judgment and decree in title suit number 94 of 79 are
Mm.
fraudulently obtained. That your lordship kindly just now read page 41.
Hmm.
That we have challenged.
Hmm.
That decree was fraudulently obtained.
But that was set aside in the by the appellate court.
Yes.
Declaration of title.
Declaration of title is there. Appellate court held that I got the declaration of right title interest
Hmm.
by long possession, that is the adverse possession.
Hmm.
So far, our prayer that the decree of 94 was obtained fraudulently, that was set aside.
No, the earlier decree was not touched by the appellate court.
Appellate court, my lord, the
Earlier decree was not challenged also in the before the appellate court. What was challenged is the judgment and decree passed in the title suit instituted by you.
no, no, the earlier suit was filed by them too.
Yes.
this. And the title suit number 24 of
Mm.
2003 was filed by us,
Mm.
stating that the decree in 94 case is fraudulently obtained.
Mm.
And we got the right title interest over the land,
Mm.
and we got the non-applicable right.
Mm.
That was decree.
Mm.
That decree, your lordship kindly see page 89.
No, in the suit lost by the defendant, uh, the earlier decree was set aside on the ground that it was obtained fraudulently.
Yes.
But that observation, that finding has been interfered with by the appellate court.
Appellate court.
And in that view of the matter, the earlier decree remained untouched.
No, so it may be untouched,
Mm.
but we got the title over the land. By the
Maybe
subsequent suit of 24.
by an earlier decree, the right title and interest already been declared in favor of the respondent herein in
Yes.
this
Yes.
revision petition.
Yes.
Mm.
My lord, so far the writ of possession is concerned, my lord,
Mm.
it cannot be executed because by the subsequent suit, we got the title over the land. And the got the title over the land, and we are in possession of the land since last 40 years.
Mm.
Now, at this stage, they have filed the execution case. That is, after the expiry of 27 years.
Mm.
The law says that the so far recovery of possession is concerned, it is 12 years.
Mm.
And so far injunction is concerned, there is no limitation.
Mm.
They can only execute the injunction part, not the recovery part.
Mm.
Our contention is this. They got the decree
Mm,
in the year, they got the decree 1984 or 12/4/1984,
mm,
and they started the execution case
mm,
9/11, 9/8/2011.
mm, mm,
And therefore, so far their right to take possession from us, it is but by time they cannot.
mm,
And so far the subsequent suit, we got the right title interest over the land.
mm,
Because I got the title by filing a suit,
mm,
and it is a civil court decree,
mm,
and that decree was affirmed by the appellate court.
mm,
Therefore, my title over the land is confirmed,
mm,
and the decree is confirmed, and I am in possession of the land.
mm,
So far, the earlier case, title suit 94,
mm,
that decree they can execute so far injunction part is concerned.
mm,
Recovery of part they cannot execute. Or declaration of title.
mm,
Declaration of title and recovery of possession they cannot execute. So far title suit number 94 is concerned. So far injunction part is concerned, they can execute. Our concern is that they have issued the writ for the recovery of possession.
mm,
Therefore, we raised an objection before the executing court that this writ cannot be executed because it is barred by time.
mm,
And the learned executing court held without going to the Order 21, Rule 32, say Article 136, executing court held that the executing court cannot go behind the decree. That is the only point.
mm,
যদি, if we have not pointed out before the executing court
mm,
that this thing is happening,
mm,
earlier suit was they have filed, they got a decree, they have not executed the decree, then we filed a suit, we got a decree, then they issued a writ of possession. We have pointed out before the executing court that so far, so far declaration of title, so far injunction is concerned, they can execute the decree. So far recovery of possession, they cannot because it is barred by time. That point was not considered by the executing court.
mm,
And the document we have filed before the executing court,
mm.
that also not looked by the executing court.
No, now the question is the earlier decree remained as it is. So what would be the fate of that decree, having not challenged before any appellate court?
That decree, they have, if it's not challenged and they have not said decree into put into execution,
Mm,
then that decree, the force of that decree will lapse by the by the limitation.
mm,
Their force of the decree was up to 12 years.
mm,
They have not executed the decree
mm,
within 12 years. Then decree is not value. It is a
mm,
simple piece of paper.
mm. limitation. Article 136.
136.
Section 57, petition. So, that is what an explanation. Doesn't treat. But because of the documents of.
Yes. So your part is over.
My part is almost over. Your lordship also see the order 21 rule 32.
Yes.
Where a party against whom the decree or the specific performance of contract or the restitution of conjugal rights for an injunction has been passed, had an opportunity of obeying the decree and has lawfully failed to obey it, the decree may be enforced in case the decree for restitution of conjugal rights by attachment of the property or the decree of specific performance of contract or for injunction by the detention of the civil prison or by attachment of the property or by both. Therefore, if I violate the injunction order, the court cannot issue any writ because he has first to satisfy himself that I have violated the terms and he has to issue notice, evidence will let. Only then the court can put a cost or put the judgment letter in prison, civil prison. These are the things available for violating the injunction order.
Yes.
At the cost of repetition, my lord, again, with respect to the first suit that was filed by me in the year 1979 for taking a decree declaring right title interest in my paper and for permanent difference. That's what my lord knows. That's what was decreed, my lord. And case number 35, my lord. 41 is the operating portion was held. That my lord, it is ordered a permanent injunction issued against the defendants that is the present petitioners not to accept the possession of the blame taking the subject in any manner. So, my lord, at that point of time, my possession was there. So, my lord, no decree was passed for recovery of possession. I was dispossessed after passing of this decree. My lord. That is number one point, my lord. Thereafter, what happened, my lord? They had filed a suit in the year 2003, saying that by way of long adverse possession, they have been able to relinquish the title of the owner and they have obtained a decree. They have got a, they're seeking a relief for
No,
declaration.
the question is why this decree was not put into execution?
Initially, madam, I was in possession. Somewhere around the year, madam, 2000, 2003, madam, I was immediately they had filed a suit, madam,
Hmm.
saying that they had admitted, madam, that they are in possession of the suit land and I am not in possession of the suit land.
Hmm.
If madam comes to paragraph number 4 of the 2003 suit, madam, that is very relevant in this regard, madam, and page number 54.
Hmm.
Why I'm saying, Myra, they are saying that they are seeking a relief for declaration on the basis of adverse possession. But adverse possession was not claimed against us, madam. Adverse possession was claimed against the government of Assam, madam. There were 12 defendants in the suit that was filed by them. I was the defendant number 1 and there were other persons and defendant number 12 is the state of Assam, madam. Now, madam, if madam sees paragraph number 4,
Hmm.
that the defendant number 1 to 11 had at page 54.
Hmm.
That the defendant number 1 to 11 had or have no right, title and possession over the suit land,
Hmm.
but the same defendant in order to grant the suit land have forced tried to remove the title from surrender. So madam, they have at the very first instance they have said that they have denied my title. That is the present defendant number 1 along with the other defendants, he has got no right title interest. If my lord, they are denying my right title interest, and as per the law that is written down in several decisions of the Supreme Court as well as by this Honorable High Court, my lord, that if you are seeking adverse possession, then you have to admit the title of the owner. Then only you can claim the right title interest, my lord, on the basis of adverse possession. So here, my lord, they are
No. You cannot raise that issue before this court.
why I'm saying, my lord, because my right title interest was there. Now they are saying that they have also got right title interest, but they are saying that this is not a Gauhati land, it is a government land, my lord. And against government land, they are seeking adverse possession. So the main case that was filed in the year 2003, that is mainly against the government, my lord.
Hmm.
Although we have made a party, but no relief was sought against us. And in fact, no relief has been granted against us also, my lord. If my lord sees the relief portion, my lord,
Hmm.
the government has been restrained from disturbing the possession. Government has been said so. But regarding the defendant number 1, they have not sought any relief against us. They have denied the title. They have denied possession of us, my lord. As such, my lord, adverse possession was claimed only against the government and not against me, my lord.
Hmm.
That is my second point. Thereafter, my lord, I filed execution case on 9/8/2011.
Hmm.
Saying that, my lord, in the meantime, I was dispossessed. So, as per the decree that was passed way back in the year 1984, in view of the title suit of 1979, I should be handed over the possession because they were directed not to dispossess me after the disposal of the suit. Thereafter, my lord, they filed an objection initially. Then, my lord, senior counsel is not argued on that point. They initially filed another objection petition, my lord. That, my lord, will find at page number 164, my lord. Raising the same contentions, madam, that it is marked by limitation, decrease in ality, madam, the recovery of possession, that was disposed of, madam, at page 164. 166, madam. Different objection of the counsel for the judgment letter number 22, that the secretary of the plaintiff has filed the suit. The nature of the suit was for declaration and permanent injunction. Next, madam, paragraph number, next page at para 5. The decree of the suit was a declaratory suit in nature and as such it is not executable. Para 5.
Hmm.
It is not executed under the provisions of CPC. Moreover, in the application, decree holder nowhere stated any date and time when the judgment letters have attempted to disrupt the possession. It is pertinent to mention here that to ascertain the present possession of the decree land, your honor was pleased to direct the Nazir of the court to verify the decree land and report in respect of the possession of the decree land to be submitted also. In compliance of which the Nazir of the court has submitted his report, which reveals that the decree land is in possession of so and so 5 numbers of the dwelling houses there. Thus, it shows that the decree holder has no possession over the decree land. So, madam, admittedly, they are saying that they are in possession, we are not in possession. And paragraph number 4, they have raised the point of limitation also, that the execution case has been filed after 27 years.
Hmm.
So, madam, this petition was dismissed by order dated 4/7/2020 at page number 169. This was the first objection that was raised by him. First petition application that was filed under section 4.
Hmm.
Today, the instant matter is fixed for passing necessary order, decree holder and judgment letter number so shall represent the to councils. There is an execution proceeding instituted on the basis of the petition submitted by the decree holders for execution of a decree of permanent injunction. The judgment letter number 5125C submitted written objection against the execution proceeding, whereby it is submitted that the decree holder has filed the application for execution after a lapse of 27 years, and as such, it is barred by law of limitation under Article 136 of the Limitation Act. It is further pleaded that as the suit was a declaratory suit in nature, and as such, it is not executable under the provisions of CPC. Moreover, in the application, decree holder nowhere stated any date and time when the judgment letter has attempted to disturb their position, as such, they pray to reject the application and dismiss the instant proceeding. I have gone to the relevant provisions, Article 136 of the Limitation Act, which prescribes the limitation period for execution of decree, provides that an application for enforcement or execution of a decree granting a perpetual injunction shall not be subject to any period of limitation. Also, Section 50 of the CPC deals with execution of decree of all kinds, including that of permanent injunction. In further, Order 21, Rule 32 of the CPC provides the mode for execution of decree for injunction, restitution of conjugal rights, and specific performance. Thus, this court is of the opinion that the instant proceeding is not barred by law of limitation, and the same is also executable under the provisions of CPC. So, my lord, already the first objection that was raised by them to an application that was rejected. Now, after dismissal of this, they have filed an instant objection, my lord, again, on the same grounds, my lord.
Not same ground. Not same.
My lord, as my London senior counsel at that point of time is stated, my lord, while submitting, my lord, they should not, I should not interfere. So I also respect the same kind of
No, no, I am not interfering like this. I am just saying.
Okay, okay, continue.
Hereafter, my lord, another application was filed, that is at page number 171.
Hmm.
That is section 47, my lord. Here again, the point of limitation was raised. I'll just read out, my lord, that the judgment letter in view of the open, peaceful, and continuous possession at page 172, para 3, my lord.
Hmm.
Against the present decree holders, others claiming interest or declaration so and so. And the defendants therein, including the present decree holder, filed an appeal category number so and so, the learned appellate court by judgment and decree dated 14/2005, affirmed the decision of the learned trial court on all the issues except the issue of setting aside of the judgment and decree title suit number 94/79, the finding of which was set aside. The effect of judgment passing title suit number 24/2003 and title appeal number 14/2005 is that it is now the judgment of the instant case who have perfected the title in the suit by adverse position, and the decree along with the decree of the permanent injunction is holding the claim. The instant decree is a nullity and is inexecutable. Where there is categorical finding in the judgment title suit number so and so, it is the present judgment letter so in continuous physical possession of the suit land with hostile animals and through decree for permanent injunction was passed against them. It could not interrupt their adverse position of the suit in view of the decree passing so and so and modified in appeal 14/2005. The instant decree is inexecutable. So saying inexecutable because it was a declaratory suit. Thereafter, my lord may come to, we have filed a written objection, and then at page number 180 is the impugn order, my lord. And the operating portion, my lord, will find. At page number 185. So this is the second round of litigation in the application. After hearing the learned counsel for both the sides, this court deemed it fit to decide all the issues raised by the learned counsel for the judgment letter one after another. Firstly, this court deems it to discuss as to whether execution proceeding is barred by law of limitation. To decide the same, this court has gone to relevant provisions with Article 136 of the Limitation Act, which prescribes the limitation period of execution of decree by clarifying that an application for enforcement of execution of a decree granting a particular ground shall not be subject to period of limitation. Also, section 50 of the CPC deals with execution of decrees of all kinds, including that of permanent injunction. After going through the provisions of law, this court is of the opinion that the instant execution proceeding is not barred by law of limitation. Perusal of the record in the same context reflects that after filing of the instant execution proceeding, the learned counsel for the judgment letter has filed a written objection with a prayer to dismiss the execution suit as the instant suit is not executable under the provisions of CPC. Perusal further reflects that by Authorization 47/2022, this court held that objection submitted by the judgment letter is not tenable. This is important matter, and accordingly, execution proceeding proceeded as filed on. That order, madam, if I may pause for a moment, 47/2022 was not challenged before this honorable court by way of a happy or revision matter. So that order dated 47/2022 is again finally And my lord, the Supreme Court, Honorable Appeals Court has held in a number of decisions, my lord, that objection cannot be raised in a peaceful manner, my lord, in installments. You file one petition, my lord, raising certain objections. Again, after dismissal of that objection, my lord, you will file another objection application saying some other contentions, my lord. That will, my lord, it will be never-ending process. So, my lord, the Honorable Supreme Court has depreciated that practice. Well, I have brought the judgment also, my lord. I will be relying upon that. My lord. Based on the submission of the learned counsel, this court deemed it fit to decide and discuss as to whether the petition filed by the judgment at the bearing so is barred by res judicata as the subject matter of the petition and that of the written objection filed by the judgment at 4/2022 are the same. In the same context, the learned counsel for the decree holder relied on the judgment of Honorable Gauhati High Court in so, whereby the Honorable Gauhati High Court dismissed a petition on the ground that matter in issue in both the petitions, one seeking rejection of claim and the other raising question of maintainability of the suit, essentially similar and the subject matter raised in subsequent petitions filed with the petitioners under Order 14(2) of the CPC is directly and substantially in issue in the previous petition. Based on the ratio held in the above judgment, applying the same to the instant suit, on perusal of the petition bearing number 269 of 2022 and the objection filed by the learned counsel for the judgment at 4/2022 on perusal of the order dated 4/7/22 dismissing the objection set up by the judgment. Whether this court is of the opinion that the subject matter and the matter in issue in the objection and in this petition bearing number 269 of 22 are directly and substantially the same. Moving forward, this court deems fit to discuss another issue raised in petition bearing number 269 of 22 as to whether the decree passing title suit number is void ab initio and therefore the execution proceeding is a nullity. Against the same issue raised in the above numbered petition, this court deems it fit to rely on the ratio held in judgment of so. Through the same judgment, the Honorable Gauhati High Court clarified that the executing court cannot go beyond the decree, and through the same judgment, the Honorable Court set aside the orders as well as the application of the judgment letter filed under Section 47 of the CPC. In the same judgment, the Honorable Gauhati High Court held that the executing court went beyond its jurisdiction in entertaining the application filed by the judgment letter under Section 47, then erred in law in allowing the application by holding the decree dated 30/3/2022 as nullity. Indeed, the interim order is expressly without jurisdiction and liable to be set aside, it having been passed against the well-settled principles of law, namely, executing court cannot go behind the decree and has to be executed as the decree is. Based on the ratio held in the above judgments passed by the Honorable Gauhati High Court, applied the ratio of the above judgment in letter and spirit. This court is of the opinion that the jurisdiction of this court cannot go beyond the decree and has to be executed the decree as it is. Moving forward, this court would like to discuss on another issue raised by the learned counsel for the decree holder as to whether the plea not taken by the judgment letter during an appeal can be raised in an execution proceeding as raised by the present judgment letter in the instant suit. To decide the same issue in hand, this court would like to rely on judgment of so and so. In the above judgment, the Honorable Supreme Court held that the decree not inexecutable as being without jurisdiction or a nullity, rather can be termed as illegal decree on account of procedural irregularity, and a plea not taken before the decree cannot be allowed to be raised during execution proceeding. In another judgment passed by the Honorable Supreme Court in so and so, the Honorable Court held that when the decree is made by a court which has no inherent jurisdiction to make it, objection as to validity may be raised in an execution proceeding if the objection appears on the face of the record. But when the objection as to jurisdiction of the court to pass the decree does not appear on the face of the record and requires examination of the questions raised and decided at the trial, or which would have been but have not been raised, the executing court will have no jurisdiction to entertain an objection as to the validity of the decree, even on the ground of absence. Coming to the case at hand, based on the ratio held in the above judgment of the Honorable Supreme Court, this court is of the opinion that the court does not have jurisdiction to entertain the objection as to the validity of the decree at this stage, as the same is not apparent on the face of the record and requires examination of the questions raised and decided at the stage of the trial. This court is also of the opinion that since the plea of nullity of the decree was not taken during appeal, the court has no jurisdiction to declare the decree passed as nullity at this stage. The petition filed by the learned counsel for the judgment letter also reflects that the present judgment letter has been in open, peaceful, and continuous possession of the suit 1960, and the decree holder had no possession in the suit land, and hence the right of present decree is extinguished for virtue of adverse possession over the suit land by the present judgment letter. To decide the same issue, this court deemed it fit to rely on the judgment passing so and so, whereby the Honorable Court held that Section 144 is applicable to case of disposition pending or where the decree is valid or reverse in appeal. Post-decree disposition in a decree for permanent injunction needs to be addressed in an inquiry under Order 21, Rule 32. Coming to the case at hand, since the said issue of possession was not raised at the time of judgment, passed entitled suit case number so whereby a decree for permanent injunction was passed against the judgment letter at the instead states where the present decree sought to be executed. The said ground cannot be raised as this court is of the opinion that the executing court does not have the jurisdiction to go beyond the decree at this stage. This court is also of the opinion that the trial court under Order 21 Rule 31 has power to restore the possession to the decree holder under Order 21 Rule 31 of the CPC with this possession. And based on ratio of the above judgment, this court is also of the opinion that there is no time limit for application under Order 21 Rule 32 of the CPC. Relying on the aforesaid judgment, the learned counsel for the decree holder stated that since the present judgment made fresh encroachment of the disputed land, the decree holder hands came before the applicant for after 27 years, as Article 136 of the Limitation Act, which sets no time period for filing of any petition. Based on the above discussions and deliberations on each point raised by the learned counsel for the judgment that the petition and the petition number so this court gives the fit to defend the petition, and according to the petition number is hereby disposed of. So, my lord, firstly, it was dismissed in the way back in the year 2020. Secondly, again, they had filed this similar kind of petition, my lord, that is also rejected, my lord. Now, my lord, the question is that without here being a decree for recovery in possession, can I, or can the learned executive give a direction to the bailiff to get the possession back to the present respondent, my lord? In my respectful submission, my lord, if I get a decree of permanent injunction restraining the defendants not to dispose me from the suit land, my lord, and if after passing of the decree, if I'm disposed from the suit land, then what would be the remedy, my lord? Should I go and file another new case seeking right title interest, which was already granted to me, and then again seeking recovery of possession, and again, my lord, number of years would go by, my lord. Instead of my filing an application under 151 or an execution proceeding, in fact, the court has ample power under Section 151 inherent power to give the possession back once my lord permanent injunction is given in my favor. That has been, my lord, buttressed by the Honorable High Court also of this court, my lord, and Supreme Court also, my lord. So my response submission that the order that was passed by the learned executing court granting me recovery of possession, there is nothing wrong, nothing illegal, my lord. In fact, there are decisions also in this regard, my lord, which can be relying upon.
Yeah, you did not file a petition under Order 21 Rule 31 also.
My lord, Order 2132 directly has not filed, but I have filed an execution proceeding, my lord. My lord knows, my lord, quoting, non-quoting of an order or.
No, that's all right, but
Specifically, my lord, I had not filed, but this execution proceeding that are instituted by me, my lord, automatically come under the purview of Order 21 to 32 or as with Section 51 of the CPC, my lord. 2017-13 SCC, my lord, that is the first judgment with regard to access possession, my lord, although that is not the subject matter, but why I'm relying, my lord, because they have paragraph number 20 and 21, my lord. Just small judgment, para 20. So the High Court erred fundamentally in observing in para 7 that it was not necessary for him to first admit the ownership of the plaintiff before raising such a plea. In our considered opinion, these observations of the High Court are against the law of adverse possession. It is a settled principle of law of adverse possession that the person who claims title over the property on the strength of adverse possession and thereby wants the court to divest the true owner of his ownership rights over such property is required to prove his case only against the true owner of the property. It is equally well settled that such person must necessarily first admit the ownership of the true owner over the property to the knowledge of the true owner, and secondly, the true owner has to be made a party so and so. So, my lord, admittedly, my ownership has to be admitted. Here, my lord, they have admitted that it's a government land. It does not belong to me, my lord. So, on the basis of that, they have got a decree for declaration of right title interest, claiming adverse possession, my lord. So, I am nowhere in the scenario, although I am made a party, my lord, but no claim has been made against me because straight away they have denied my right title interest, my lord, and the suit was mainly for adverse possession. So if they would have admitted my title, my lord, then I would have come into the scenario. And my right title interest was way back in the year 1984, my lord, declared by a competent court. Against that, they have not prepared any appeal. First appeal or second appeal, not a single appeal was prepared. Secondly, my lord, Honorable High Court on the very same facts, my lord, exactly on the same facts. The whole judgment is on the same facts, my lord. Kalyani Swain. Paragraph number, my lord, I'll be relying upon. The whole judgment is not relevant, but I'll be cutting short. Paragraph number 3. The facts of the case relevant only to decide the present application are that one, petitioner Swain, the father of the opposite party, had filed title suit number 148 of 1981 against the father of the petitioners for declaration of right, title, interest, confirmation of possession, and permanent injunction over Schedule C land property prescribed in the plea. The suit was decreed by declaring the title of the plaintiff, confirming his possession, and by permanently restraining the defendants from interfering with the possession by judgment and decree so. The defendant paid appeal being so and was also dismissed, confirming thereby the judgment and decree of the trial court. The defendant paid further appeal to this court being RSA number so, but the same was also dismissed. Thus, the order of the trial court attend finally. Here, no appeal is filed in our case. Decree of the loss execution being execution case number 13 of 2012 on 2011-2012 alleging that the judgment debtor forcibly occupied the Schedule C land. Upon receiving notice, the judgment debtor filed objection under section 47 of the so. State application was dismissed on 16/10/2019. The judgment debtor again filed a petition questioning the maintainability of the execution case, which was also rejected by Dr. So by the same order. The executing court directed the decree holder to take necessary steps and for payment of fees for issuing writ of delivery of possession by evicting the judgment debtor. It is stated that state order was complied with by the decree holder on 18/2021. The judgment debtor again filed an application under section 47, which was again dismissed on 25/10/2021. He thereafter preferred revision against such order before the first edition district judge, but the same was also dismissed on merit. Despite the rejection of such application, the judgment debtor again filed an application under section 47. Para 5, the executing court heard both the parties insurance which filed basically on the grounds that the decree being one for confirmation of possession and not for recovery of possession, that execution case file seeking recovery of possession is not possible. Para 6, after taking note of all relevant facts and the repeated filing of application by the judgment debtor under section 47, the executing court was of the view that the decree of confirmation of possession can only be satisfied by granting recovery of possession by evicting the judgment debtor from the suit land. The executing court also found that the same issue having been raised earlier by the judgment debtor had been considered and rejected. On such findings, the executing court dismissed the application under section 47 CPC. Being agreed, the judgment debtor filed a revision petition before the first edition. Para 8, on the question of limitation, the revisional court observed that the decree in question was not only for declaration of plaintiff's right, title, interest, and confirmation of possession, but also for permanent injunction. Therefore, Article 136 of the Limitation Act does not apply for the doctrine of merger would be applicable in view of filing of so. On the question of maintainability of the execution case for recovery of possession in the absence of any decree being passed to such effect, the revisional court was of the view that since all the three courts confirmed the plaintiff's possession over the suit land, it can be presumed that the entry of the judgment debtor over the suit property was after disposal of the second event. Therefore, the decree holder can seek execution by evicting the judgment debtor. Para 14 thereafter. Before delving into the merits of the contention raised, this court observes that multiple applications questions the maintainability of the execution case with filed by the judgment debtor and rejected. The latest application, which is the subject matter of the present file purportedly under section 47 of the CPC, was rejected by both the courts. Section 47, I'm not repeating my para 15. It is borne out from the record that the latest application filed by the judgment debtor was the third such application. His previous two applications being rejected. Fundamentally, repeated applications being filed more or less on the same issue cannot be entertained, adopting the principles of res judicata, though not res judicata proper. In case of so and so, the Supreme Court observed, experience has shown that various objections are filed before the executing court, and the decree holder is deprived of the fruits of the litigation. And the judgment debtor, in abuse of the process of law, is allowed the benefit from the subject matter which he is otherwise not entitled to. The Supreme Court also made it clear elsewhere in the judgment that all frivolous and malafide objections resistance raised to the execution of the decree should be dealt with sternly. Para 17, my lord. Significantly, the judgment debtor does not contend that he has not entered into possession, but raises objections on technical grounds, such as absence of decree of recovery of possession, limitation, etc. In such fact situation, relegating the plaintiff to file a fresh suit for recovery of possession would tantamount to nullifying the decree passed in his favor by all the three courts earlier. The judgment debtor cannot obviously be allowed to frustrate the decree against him simply by stepping out of the suit lane and claiming that there is no decree for recovery of possession by his eviction. It would be giving a handle to a person who has lost the litigation at all stages. It would also amount to an abuse of the process of the court. having held as above, fact that the executing court took note of the objection raised and rightly held the degree of confirmation of possession can only be satisfied by evicting the judgment debtor from the suit led. It is a case of removing the obstruction caused by the judgment debtor to enforce the degree of confirmation of possession. The divisional court has vividly discussed the questions raised to hold that the decree holder, having got the relief of permanent injunction, can file an execution petition to evict the judgment debtor whenever it is found to have interfered with the position of the decree holder. This court fully concurs with the reasoning adopted by the divisional court. Coming to the grounds raised by the judgment debtor, this court observes that the first ground raised is with regard to limitation. It is contended that decree being for title and confirmation of possession execution ought to have been filed within 12 years. This contention is considered only to be rejected for the reason that the decree in question was not only for title and confirmation, but also for injunction in restraining the defendant from interfering with the possession of the plaintiff. Since it is alleged that the defendant had interfered with the possession of the decree holder or forcibly entering into the suit property, the execution case cannot be held to be barred by limitation fee of the specific provisions under Article 136 of the Limitations Act, which is quoted here. But there are other paragraphs also. I will not be going into those. But my lord, this judgment squarely covers our judgment of our case also, my lord. Thereafter, my lord, 2002, ALT 121, paragraph number 6, 7, and 10. Here, my lord, it says that, my lord, you are filing execution case also, my lord, under 151 of the inherent powers of the court, restoration can be allowed, my lord. Paragraph number 6. Mr. P.K. Bulwa, the learned counsel for the petitioner, submits that the learned assistant district judge was fully within jurisdiction to pass the review judgment directing the restoration of possession of the suit property does not suffer from any error of jurisdiction, making it liable to be interfered in civil division as it relies upon so and so. There are 8, if I consider the opinion on the aforesaid facts and circumstances, the learned additional district judge was fully within his jurisdiction to issue mandatory injunction restoring the possession of the land in favor of respondent number 1 and 2. In the recent decision of the Supreme Court in case of Delhi Development so, the Supreme Court discussed the law on this point as to whether a contender should be allowed to enjoy or retain the fruits of his contempt. After considering a large number of authorities on this point, including decision rendered in so and so, the Supreme Court held that a contender should not be allowed to enjoy or retain the fruits of his contempt. In paragraph 20 of the judgment in the case of the authority, the Supreme Court had discussed the judgment of the division bench of the Calcutta High Court in the case of Sudeep Paul, in which the defendant forcibly disposes the plaintiff in violation of the order of injunction and took possession of the property, and the court directed restoration of possession to the plaintiff with the aid of police, observing that no technicality could prevent the court from doing justice in exercise of his inherent power. The object of Rule 2A Order 39 would be fulfilled only where such mandatory direction was given for restoration of possession to the agreed party, and that was necessary to prevent the abuse of the process of law. In view of the aforesaid observations of the court, in my considered opinion, the learned additional district judge was fully within the jurisdiction to pass the interim judgment that order directing the restoration of possession of the portion of the suit property in favor of respondent number 1 and 2. The said judgment in order of the learned additional district judge was passed on a complete violation of the orders of temporary injunction which took place in the year 1991 by the respondent number 3 to 6, inducting the petition number 1 as a lessee in the portion of the suit property for selling so and so. In respect in one. And in respectful agreement with the decisions quoted above, it is the duty and the responsibility of the court to see that an order of injunction passed by it is meticulously implemented, followed. Otherwise, an order of injunction will be a mere paper tiger without having the force to buy. That is not the purpose for granting an order of injunction. An order of injunction creates certain rights and liabilities between the parties, and that order of injunction must be enforced by the court by passing necessary order. That is also necessary to shorten the litigation inasmuch as if that is not done by executing a decree for perpetual injunction, the person will be put in possession on a particular date, and on the next date, by its power, the defendant may again take back the possession of the land. It cannot be the object of the purpose of law. In such a situation, a person so dispossessed is not to again go for a fresh round of litigation to establish his right and to get the order for recovery of possession. He can approach the court of filing necessary application under section 151 of the CPC to obtain an order for restoration of possession, and the court in such a situation can always give back or restore the possession. With this way, restoration was handed over, restoration of the suit property is handed. But thereafter, a small judgment is there, with regard to issue SFL. Already the issues have been with regard to maintainability limitation that was discussed in the first application, my lord, and which was dismissed in way back in the year 2022. So, my lord, the next decision 2005 1 SCC 787, paragraph number 30, my lord, short para, that once the issue is decided, it again cannot be reopened, my lord. Para 30, res judicata debars a court from exercising its jurisdiction to determine the lease if it has attained finality between the parties, whereas the doctrine issue as well is invoked against the party. If such an issue is decided against him, he would be stopped from raising the claim in the later proceeding. So, here also, my lord, already the application the first application by section 47 was dismissed by the Honorable Executing Court way back in the year 2022. And thereafter, my lord, AIR 2021 SC 4756. That is with regard to, my lord, that objection cannot be raised in peaceful manner or on installment basis. In one petition, my lord, we have raised certain objections, in another you file another objection, my lord. That way it cannot be appreciated. So these are the judgments, my lord, I'm relying upon. So, my lord, my resolution submission is that there was no illegality done by the learned executing court, my lord. Otherwise, there is no way out. Because once an order for permanent induction was passed in my favor, my lord, thereafter, if I am disposed, already remedy is that, my lord, I'll go for an execution process, to file an execution process to get back my position, my lord. Otherwise, again, to go back for another round of litigation, my lord, that would be taking the precious time of the courts also, judicial wastage of time, plus the wastage of the litigants' time also,
Okay.
my lord.
Yes, any reply?
Yes. But the the first petition we have filed
Hmm.
for the before the executing court,
Hmm.
that is at page 166.
Hmm.
That petition is filed by the Council of the Judgment Letter number 51256. Reply to an application of the execution of the decree. That is, it is stated the white suit number 94 of 79.
Hmm.
That the nature of the suit for declaration of permanent injunction. The decree was decreed on 18/4/1984. Operating a part of the decree is this. It is ordered that the suit is against the defendant number 1 is decreed on contest ex parte against the defendant without cost. The plaintiff suit is declared for permanent injunction and not to disturb the position of the plaintiff. The suit also decreed on suit was decreed on 18/4/1984. Well, this application filed by the advocate representing the judgment debtors, and this is not a petition under section 47. It is a simple written objection by the judgment debtor regarding the execution of the case. 47 is this, my lord. The section 47 is execution, satisfaction, and discharge of the decree. So therefore, as this petition was rejected, and the execution will proceed, then the original judgment debtor, they have filed a application under section 47. That application of 47, it cannot be termed as a res judicata or any other thing, any other. And my lord, what my learned friend has submitted, that no subsequent various petition after petition, and the number of orders cannot be challenged in different courts. But in this revision, we have challenged the order dated 4/7/22. That is the order passed on at Annexure 8. And 13/10/25. Both the orders are challenged. It is not that we are slipping over that order, because our section 47 petition was rejected. Then we have filed the petition under section 47. That section 47 petition was the handing of the executing court is not according to law. Because the executing court has not gotten into the merit of the 47 petition. It is execution, discharge, and satisfaction. 3 questions. Here, the executing court ought to have held that whether the execution case is barred by time, whether it is filed under after the 27 years of the decree was passed.
Mm.
By subsequent title to property.
So, in one of the decision, the Andhra Pradesh High Court has stated that this Article 136 is not applicable.
Proper injunction is passed.
I have satisfied your lordship at 2.
Mm.
I will satisfy your lordship at 2 p.m. madam.
Okay.
Lordship, due to inadvertent confusion regarding the item number, Lordship, the matter could not properly mention earlier, Lordship. With the consent of the appellant, sir, I beg to mention item number 15, Lordship. Lordship, my senior LJ Bose is out of station, Lordship. Kindly adjourn for the day, Lordship.
Item number 1515. Miss, your name, please?
RD, appearing on behalf of AJ Ghosh.
Ardev, Learned Counsel, appearing on behalf of Mr. A.J. Ghosh, Learned Conducting Counsel for the respondent number 1 to 5. You inform the other side?
Yes, Lordship.
I'm for that.
Okay. No objection. With consent from the other side, press for listening the matter after
After 2
weeks. Here allowed.
of last.
Okay. Yes.
Is there a persuasion?
The first court say the person definitely is here and finally takes it.
Yes.
Yes, ma'am. May I please? Mother, I want to some points, mother.
Mm.
My learned friend has argued on the adverse position.
Mm.
Because that adverse position they cannot claim, because in our suit we got a decree over the land and it has got its finality. There was no further appeal preferred by the other side. Therefore, the adverse position they have claimed is not valid. And at one point they have challenged that I filed one objection in the execution case that it cannot be executed. It is time barred. That is on where that is I filed a petition 166 page.
Mm.
That petition was heard and disposed of on 4/7/22.
Hundred and 61.
166 petition. Written objection. On a written objection filed by the judgment letter regarding the executability of the decree.
Mm.
And that petition was rejected.
Mm.
That petition was rejected on 4/7/22
Mm.
at page 169.
Yes.
And thereafter I filed a petition under section 47.
Mm.
And that petition was disposed of on 13/10/2025
Mm.
at page 180.
150.
180.
180.
My petition under section 47 was disposed of.
Mm.
And my earlier petition is not under section 47. My earlier petition is not under section 47,
Mm.
but subsequent petition is 47. Both the petition were disposed of. My lord, and in my cost title, your lordship kindly see, I have challenged both the orders
Mm.
at page 1. Order dated 4/7/22 and 13/10/25. And they said, and the same proceeding, it can be challenged, 2-3 orders can be challenged in one case. It was held by the Allahabad High Court, this decision.
Mm.
Paras 16 you will also kindly see.
Mm.
In our opinion, therefore, looking to the nature of the improved order dated 24/1/22, 3/3/22, and 5/3/20, a single revision is maintainable by the revisionist.
Mm.
17. And 17, paragraph number 7. Therefore, there is another pragmatic angle for looking work to the respondent's objection. By the order dated 5/3/22, the execution has been struck off on full satisfaction. If the revisionist were asked to file a separate revision from all the 3 orders, and any of these cannot be individually heard, and or may even to maintainable unless all the 3 orders are silenced. Therefore, the separate revision, all the revisions are together. The order impugned in all are all but part in one challenge by the revisionist arising out the same execution. Therefore, 2-3 orders from the same case
Mm.
can be selected in a one revision petition. And my learned friend also submitted my subsequent suit, that is title suit number 24. I have prayed for the decree against the state government
Mm.
and not against the defendant.
Mm.
My lord, the prayer portion of that plaintiff will also kindly see. Paragraph 59. Or a decree declaration that the plaintiffs have acquired right title interest over the suit land on the strength of their long adverse person for more than 40 years. And my lord, I have filed this suit not only against the government. Government is a party, but I have claimed the right of adverse person from the defendant number 1 to 11, and 12 is the state of Assam.
As consequence.
Hmm? Paragraph page 59, you also can see prayer number C,
Page number
59.
59. Hmm.
Decree basis, no? Prayer C, a decree for perpetual and temporary injunction restraining the defendants, their men, women, and agents from entering into the suit land and also from disturbing the possession of the plaintiff over the suit land. And that portion also decreed in my paper by the trial court. But I want to place one decision of under for order, order 21, rule 32. Order 21, rule 32. Degree for specific performance for restitution of conjugal rights or for injunction. Where a party against whom a decree for specific performance of contract or restitution of conjugal rights or for an injunction has been passed, has had an opportunity for obeying the decree and has willfully failed to obey it, the decree may be enforced in case where the decree for restitution of conjugal rights by attachment of the property, or in case of the decree for specific performance of contract, or by injunction, by detention in the civil prison, or by attachment of the property, or by both. When one party has decree, it is a decree for violating the injunction orders. They have stated that we got the injunction order, therefore they file the execution case to implement the injunction order. That injunction order, if I violate, that cannot be kicked out from me from the land. It is the procedure laid down there, they have to lay evidence, and if it is found he is disobeying the injunction, then he is to put civil prison or arrest or with fine. Attachment of property and others are there. Therefore, the the order 31 and rule 21, rule 32. Decision, I have already given you. Coercing signing. Para 18. In case of any grievance for non-compliance of the term, in
Yes.
case of any grievance in non-compliance of the terms of the decree passed in the civil suit, the remedy available to the aggrieved person to approach the execution court under Order 31, Rule 32.
Mm.
32, which provides for an elaborate proceeding in which the parties can adduce evidence and can examine and cross-examine the witnesses as, as opposed to the proceeding in contempt, which is summary in nature.
Next.
There, my lord. And paragraph 21 of that judgment you will also can see. Paragraph number 21. The provision of Order 21, Rule 32 applies to prohibitory as well as the mandatory injunction. In other words, it applies to the cases where the party is directed to do some act, and also the case where he is abstained from doing such act. Still, to put it differently, a person disobeyed the order of injunction not only when he fails to perform the act which is direct to do, but also when he does not act that which he prohibited from doing. Execution of injunction decree is to be made in pursuance of the Order 21, Rule 32 CPC, provides the particular manner, mode, and execution thereof. Therefore, the execution case, when the writ was issued for possession, for possession and injunction, for possession and key, or possession. Then I read. And I read. None. Execution petitions copy 171.
Once.
163.
Yes, anything more?
163, you subsequently see. Page 164. I pray that the dependent number 2347, matter of possession and injunction. Matter of possession and injunction. The injunction cannot be executed. He has to prove that I have violated the injunction order. Only then it can be issued. And so far possession is concerned, I have already stated that we filed a suit. We filed a suit in the year 2003. That is the title suit number 24 of 2003, where I got a degree. And my position was confirmed as on adverse position. Therefore, my title over the land is perfected by a decree of the competent civil court.
Okay. Heard. Mr. S.C. Sharma.
Another judgment was also finished. It will be. Para 13 of this judgment. Issue paragraph number 13 of the PC. Issue number 1 and 2 are categorically decided. Because the conditional relief granted to the civil court as against the finding recorded under the issue number 1 and 2 and para 11 of the judgment. I am of the view that the proposition is not covered by dismissing the execution in time, but in terms of section 135. Apparently, suit was filed for declaration as well as mandatory injunction, for which the issue number 1 and 2 is distinctly different. Both the issues were decided in favor of the plaintiff. Therefore, the decree was not simpliciter a decree for mandatory injunction. Rather, it is a composite decree of declaration as well as mandatory injunction. Therefore, the plaintiff suit is covered under Article 156. If it is covered, if their case, their decree is covered in 136, then it is 12 years. The execution case is time barred. And declaration of title is time barred. So far execution injunction is concerned, they have to issue notice, they have to prove.
My lord, just one judgment I have given, my lord, 37 and 30. My lord, kindly note down the paragraphs, my lord. I'll not take much time. 37 and 38, it relies upon, my lord, what needs to be done when a permanent injunction is violated, whether execution proceeding is liable to be maintained or not. And 41, 42, 43 is with regard to the point of limitation. 37 and 38 with regards to the remedy for violation of the permanent injunction, 37 and 38. And paragraph 41, 42, 43 is with regard to limitation.
हमारे लिए दिख रहा है जितना एक्चुअल में जैसे हमारे लिए तो की केसेस
Heard Mr. Assisson, learned senior counsel assisted by Mr. Vardas, learned counsel for the petitioner, and Mr. Iqbal, learned counsel for the respondent. Argument concluded, order is it.
Declare.
Hearing further question, I can upgrade it. Item number 21.
My lord, exhibit 11, that is, that's a type copy, my lord, your lordship has directed. Copy. Okay. Shillong property, my lord. My issue is this, whether Shillong property is Gauhati property. Shillong property, my lord, they have related exhibit 11, that is by family settlement, she become the owner, because son and daughter both should be the equally, but since there is a family settlement, that is why Shillong property they have got. And our claim is that Gauhati property falls in our share, and it is acted upon for last 27 years. After that, partition suit is filed. So last occasion, your lordship has directed us to give a type copy of this. Where say, how is the mention of the family settlement? That dispute was settled, my lord, on the basis of family settlement. This court, Shillong court has adopted that there is a family settlement, and it is pleaded by them only. Here, my lord, page 3, my lord. The
Page
suit
3 of the
property
petition.
includes.
Of the appeal. Page 3 of appeal.
No, my lord. That exhibit 11, my lord.
This one.
That yes, type copy I have given, because record is not legible very much.
Page number 3.
Yes.
Hmm.
They are defendant in that case, and the suit property in Shillong, this is 1 bigha, in Gauhati is also 1 bigha, my lord. Transferred to OP, defendant number 1. We have filed a case there, so they have the defendant there.
Where is the order of the Shillong court?
Well, exhibit 11, my lord, of the records of PW evidence.
Exhibit 11.
Yes.
C1.
Twenty-three to 2001, my lord. This is the title suit 5060 of 1991. The appellant has filed there. There is a miscase and this order is there. So concept of family settlement, they have adopted there, it was they have pleaded, it is adopted.
Index of the class, page number.
Okay.
6 to 53. Number.
Yes. Definitely.
To what?
Exhibit number? Exhibit?
Exhibit 11, my lord. Page, I think, here. They have exhibit 1, 2, 3, 4, 5, 6, 7, 11. PW1 witness.
11. Title suit. But this is also not legible.
My lord,
This is also not legible.
that is why your lordship has directed me to bring a type copy. I have brought this type copy of this.
Which is the operative portion of this type
My
copy?
lord, page 3, my lord, page 3. In Shillong, they had pleaded that there is a family settlement. That is why Shillong property, although joined, but it is we have relinquished. That is why she is the absolute owner of that property. The suit property in question, that is in Shillong, was transferred to OP defendant number 1 far back in 1974 by transferring the name of their father, late Indranath Hazarika. Indranath Hazarika was the original patadar. His son and his daughter. This appellant and respondent. And there, she is the defendant of the plaintiff. By transferring the name from their father, late Indranath Hazarika, to the name of defendant number 1 on basis of the family settlement after death of their father. The learned counsel submitted that the plaintiff himself was power of attorney holder and he received the pata number so and so on 6/12/74 after the transfer of the suit property to the defendant. So he relinquished because of the family arrangement in 1974. In Gauhati, my lord, our mutation is 1967. And till 1991, my lord, they have not, they enjoyed peacefully, both Shillong property and Gauhati property. No partition suit was filed. So that is why I raise a question whether it is barred by limitation when they are settled, already got settled with their own share, my lord. So family settlement, they have said that we have not pleaded that in additional, my lord, amended WS we have pleaded. But then we said that this is the concept they have in Shillong court, they have, my lord, raised and adopting that they got the degree of whole property of the Shillong. Now they also claim the half share of the Shillong being a joint property. So our humble submission is that in 65 the patadar died and 67 our name has been mutated. The mutation order is Annexure D. Then, my lord, in 71, bank call when we, by depositing title documents, we want loan, equitable mortgage, then from Pata, all the legal heirs are called upon, and that is settled that it is transferred to us. Because Pata was not in our, but mutation are there. Chitha is in our name. And after their consent, we have given the loan. We have building is we have constructed building enjoying since 1967. Whatever, my lord, 1991, my lord, they want to sold some portion of the Shillong land by the plaintiff. We oppose
And they the counter plus a partition suit is filed here, my lord. So my contention is that if so many years they are peacefully enjoying and it amounts to acted upon, my lord. Now whether partition suit at this stage is maintainable or not, that question was not formulated. That is why your lordship directed me to give a legible copy that whether Shillong order, my lord. Page 11 also, my lord, kindly see. 11, issue number 2, that whether the suit is barred by law of limitation and principle of estoppel, waiver, and acquiescence. Here also, my lord, petitioner defendant in the petition contended that the suit is barred by limitation. The petitioner defendant in her WS, as in her petition, stated that date of her father, defendant, late Indranath Hazarika, under this mutual agreement and understanding between the plaintiff, his mother, and Sola Hazarika, the defendant, it was agreed that Shillong property mentioned in the Schedule A and B of the plaintiff would go to the defendant. Look, exhibit 5 is the, my lord, revenue records, my lord. It says that in 1967, our name is, the name of the appellant is mutation. That order is not challenged by the plaintiff whose partition after 30 years. That was not challenged, my lord. So, my lord, as per Umiyuki Das versus, so revenue entry is presumed to be a correct until rebuttal evidence or it is challenged, my lord. They have not challenged. That is why it attains the finality, my lord. And presumption is that due to relinquishments of Gauhati property, they have never challenged. And like the Shillong property also, we have given no objection to that, my lord. It was settled for more than 2 decades, 3 decades. After that, some partition suit was filed. So our objection is there whether this means or it is time bound. Annexure D, that, my lord, of our evidence, this is the mutation order. It was in 66. Next, I'm going to do some. I'm not. How do you say? Lucky luck. Good. Lucky luck. Good.
That
More-
family settlement deed is part of the
It
record.
is, yes, it is oral, my lord. That is our case. Oral, both side oral, but it is acted upon. So there is a judgment if family settlement is oral, if it is acted upon, then my lord, oral family settlement is also bindings.
Where is that just
Only. Three judgments everyone, my lord. But it is- Moreover, my lord, one thing is that the plaintiff respondent, if she is the owner, joint owner, why she is a tenant, my lord? She was tenant till that she has no possession. Since death of his father, 1960, she was not possession, but she took a rent. And cause of action arose in 90 when she refused to pay rent. And notice was served after the death of mother, Suala Hazarika.
Mr. Borua, you see, this is not a first appeal, this is second appeal.
Yes, my lord. The question.
We have to consider only the substantial question of law.
Yes, my
You
lord.
argue on that, on the substantial question of law,
Yes, my
not
lord.
on other things.
Yes, my lord. So here,
So,
my lord.
which part of this judgment you are relying upon? Which paragraph?
My lord, paragraph, my lord, this first judgment, paragraph number 33, my lord. Here the case is that, my lord, A and B, both the brothers, they have family, there is a family settlement, and the Pita, which is false, the schedule A, is one brother and others falls to second brother. Then what happened? Second brother is allowed to stay in Vita.
This paragraph number?
Paragraph number relevant, my lord, findings is paragraph number 33, my lord. And here it is said that mutation was granted in elder brother, but the younger brother was staying in the Vita. After that, when he was asked to vacate, he filed a partition suit that I am the joint owner. But here, mutation order as well as this Sitha, he has never challenged this. On that counts, this Honorable Court says that this is a presumption is that due to family settlement, they have never challenged, and now after so many years, is not allowed to challenge this.
Paragraph number 33.
33 is yes, my lord. 33 is the findings, my lord. At this it is on the count that, my lord, 1976 this partition was taken place, and accordingly the mutation was done. Although joint property, it mutation done in respect of only elder brothers. Now younger brothers come partition after so many years later. So Honorable Court says that the entry in revenue records presumed to be true unless rebuttal evidence is there. There is no challenge to this. So it leads that there is a family settlement. Accordingly, this partition was mutation was done. They have not challenged. now reach to unsettle this, the partition suit is filed. That is why, my lord, their prayer is not granted, my lord. Another second is that, my lord, in this point, my lord, another Supreme Court judgment. When partition suit is filed after so many years, then my lord, order 7, rule 11, the objection was made, and dealing with this, the same, my lord, ratio is adopted, my lord. It is like the reopening of the dispute.
No, in that case, the family settlement was admitted by the parties.
Well, that here also admitted, because when we take a loan, then I also admitted there, because we gave the no, my lord, in her mutation, I also relinquished my right. Both party, my lord, previous occasion, both parties agreed, my lord. They have no dispute. After 27 or 30 years, dispute arose, my lord. They are in peaceful possession. She is in peaceful possession of Shillong property. She sold up, even sold the properties. Being and Guwahati property, my lord, we are enjoying till today. She has no possession upon this since 1965, 67. Now they want to agitate this by partition suit. So, my lord, the third is Kale, my lord. Here, oral is bindings. That is third judgment is, my lord. Era 7, and my lord, here also, the after discussing all these things, my lord, it comes to the conclusion that oral, if orally both sides settle, it's oral evidence without registration. No registration is required. Because family matters, my lord, to save the family for litigation, family settlement orally also acceptable, my lord. It's not third party. And both parties are satisfied with their and settle. And suddenly, after so many years, they came with a partition, my lord, to disturb this.
Okay, your part is over.
My lord, this is my contention regarding the formulation of a new substantial question of law.
Mm.
My lord, this much. And then I have to go through this. If this question is formulated, then this evidence part out like this. But basically, on these documents, my submission is that
So,
already documents.
what is your argument on the framing of new substantial question of law, additional substantial question of law?
My lord, whether the partition suit is barred by limitation. When the their oral agreement, they have settled with their share, or my lord, it should be
When the oral agreement took place?
in our Guwahati 1967. 65 the father died, and 67 by oral agreement mutation was granted in the name of this appellant.
No, no.
And-
Oral agreement was entered into by the parties in which year?
in 1967.
67.
And they said that in 1974, she was become the owner because of this oral settlement or oral agreement of Shillong property. That is why they have never challenged each other's. But
And when the Shillong property was settled?
74. Before that, but in 74, she became the owner because of it.
No, when the oral agreement in respect of Shillong property was entered into by the parties?
My lord, 1965, my lord.
65.
Yes, both Shillong and Guwahati, but land is transferred to
Father died
65.
65. An
Yes.
oral agreement in respect of Gauhati property was entered into in the year 67. And Shillong?
At the same time, oral
Same
agreement.
year.
But in case of Shillong, their mutation 74. So she got the mutation in 74 because this oral agreement. And we have also relinquished by putting signature and no objection. Then, my lord, 71, my lord, when the bank asks from C, my lord, to, my lord, it is exhibit 8.
Now the question is whether any issue was framed by the trial court and also by the first appellate court.
Limitation, for instance, limitation section, Article 64 of Limitation Act, there is an issue, but that is time but
No, whether yes, issue was framed
yes,
and there was discussion on the issue.
my lord. But
And-
evidence, this evidence was not properly, my lord, appreciated. This facts was not properly appreciated. They
No,
says that
you say in second appeal we cannot reopen the facts.
my lord, yes. But
Here only the substantial question of law.
yes, this is question of law can
So
be
if there is concurrent finding of fact
yes, my lord.
on the point of limitation, then this court has no ground to reopen the same.
Yes, my lord.
So where is the point for
My lord,
framing additional substantial question of law on this point?
my question is that, my lord, whether this partition is at all maintainable. My contention is that, my lord, once it is settled, again reopen, my lord. Second partition is the reopen of the others to controvert this other partition. That is oral partitions. So whether it is allowed. Because, my lord, if oral partition was not there, my lord, orally, then, my lord, they have included the other properties, that is Shivsagar, Shillong, and Jorhat in their plane. My lord, they have excluded it because there is oral partition. They have enjoyed the Shillong and Shivsagar property, Guwahati property is there. Now, to get benefit, whether this is, my lord, again reopen and that is to discard the other already settled position. That is my. If they were in possession, joint possession is continuous. They are never in possession. Because rather they are tenant. And when being tenant, they paid rent. When rent was not paid, cause of action arose. Now they file a partition suit that I am also 50% owner. So why should I give rent? But 67 to 90 is they are paying rent. This notice is, my lord, cause of action. This notice is also exhibited in their exhibit number 4.
On the point of limitation and maintainability, there are concurrent findings.
Hmm.
The trial court as well as the first appellate court.
Okay, in the first appellate court, in which part it has been dealt with?
First appellate court.
Hmm.
Something in which part? So the first appellate court at para 13, Roman 8. Page 51.
Hmm. Hmm.
At the bottom.
Hmm.
Accordingly, it is incumbent to give it the real settled proposition that in order to establish a one co-heir and against another, it is not enough to show that one out of them is in sole possession and enjoyment of profits or property. Outside of non-protecting co-heir by the co-heir is possession who claims this possession to be advised should be clearly made out. The possession of one co-heir is considered in law as possession of all co-heirs. Thus, one co-heir is found to be in possession of the property that is presumed on the basis of the joint title. So that is on adverse possession.
Hmm.
Then
No, no, on the limitation point.
yes, I'll show. First, on the limitation point,
Hmm.
the trial court, first the trial court's finding at page 50.
Hmm.
Page 50. middle.
Page?
Page 30. Middle. The defendant decision on issue number 3 and 4.
Hmm.
The defendant pleads with the paragraph 5 of the written statement that the plaintiff was never in possession of land and the defendant has denied her title in 1967 and such the suit is barred under this sort of limitation act. A vain such has to undertake it to go through the deposition of defendant in affidavit which does not contain any trace of adverse position, let alone proof. The proof of adverse position against the co-owner requires strong existence of facts which could show complete ouster of the co-owner, else even if the co-owner is not in possession of joint property physically, his possession is deemed to be in such and every parcel of the property. The proof of adverse possession must come from the person who sets up the plea as when the possession has become adverse and when it ended long possession does not necessarily prove adverse possession. Mutation of land in favor of defendant is urged to be a circumstances to prove adverse possession. Mutation of property may confer title only in case of previous ownerless property because in such an event the mutation would mean existence of better title against the others. In the present suit, the mutation was granted on the property acquired in the form of inheritance and mutation of the legal is in the instead of the deceased owner is but natural. Even if the consent of the was assumed to have been given by the plaintiff, it would not mean conferment of title upon the defendant and for a period of commencement of adverse possession. The pleading of both sides would show that the dispute with respect to the suit property began only in the year 1990 and prior to 3 years. There is no proof of any claim title or denial thereof. Thus, the suit considering the date of cause of action has been filed within 12 years. So this is the trial court's finding. And the first appellate court, the judgment starts at 45th. But at 46, there are 6 my lord will say. Page 46. Trial court framed the issue of limitation as issue 3, para 6(3).
No, where is the discussion?
Yes. Under the B.
Hmm.
Page 47, 10.
Hmm.
Sorry, those are the grounds on which we challenge this. Then the discussion starts at page 50. Page 50, the appellate, first appellate court names the issues. And at page 51, Roman 5.
Hmm.
Now I intend to consider decision of the learned trial court in issue number 37, that is whether the suit is barred by limitation, whether the defendant has acquired title over the entire suit land by right of adverse possession.
Hmm.
Now, 6, it appears on the record that the learned trial court has decided both these issues in favor of the plaintiff respondent, noting that the suit being filed within 12 years time period from the commencement of dispute within the parties since the year 1990, as reflected in the pleadings of the parties, the same is not barred by limitation. And further, that since the proof of adverse possession against co-owner warrants strong existence of facts showing complete absence of co-owner and the said aspect being also conspicuous in its absence, as such the claim of adverse possession is unsustainable. In examining the said position upon the rival convictions, it appears that the admitted position of the parties is that the suit property belongs to their predecessor in title. Accordingly, it is incumbent to revisit the settled proposition of law in order to establish adverse possession. Then there is finding on adverse possession. And at 11, Roman 11,
Hmm.
upon the record, it is further appears that it is rightly noted by the learned trial court that the evidence of the dependent appellate side failed to surface any trace of contention or adverse possession. Therefore, I am of the considered view that the finding recorded by the learned trial court as regards both the issue do not suffer any infirmity, and accordingly, I concur with the finding of the learned trial court in these issues. So the issue of adverse possession and limitation were considered together.
Hmm.
But well, before that, a fundamental issue, subject to finishing. The family settlement was never pleaded. This is not a case where they pleaded family settlement in their defense.
Hmm.
The controversy is very simple. But we are the legal age. The parents left behind multiple properties.
Hmm.
Now, on the death of the parents,
Hmm.
there was this one Gauhati property which was left.
Hmm.
I filed the suit saying, being a class 1 legal heir, I am entitled to half of this property.
Hmm.
And I sought partition.
Hmm.
To this suit, a written statement was filed.
Hmm.
There was no claim of family settlement. There was no claim of relinquishment of any right. Subsequently, an amended WS is filed. And if my lord sees the pleading
Before the trial court.
before the trial court,
Hmm.
my lord will for a moment come to page 24. This is the only pleading based on which the family settlement has been argued.
No, there was a pleading before the trial court in
Yes.
respect of that issue, family settlement.
14G.
Please see page 24.
No, now one thing, Mr. Borua has contended to frame additional substantial question of law on the point of limitation. But since there is concurrent finding of fact
Yes.
in respect of limitation by the learned trial court as well as the first appellate court, there arises no occasion for this court to framing any issue on this point. There is concurrent finding of fact.
My lord. But
Now, are you ready to argue the matter?
my lord, I think I should with a better preparation on that may be fixed because AK Purgasto, the senior, he's also there. He's taken lead today. So one short date may be given will satisfy lordship on the.
Okay. But you cannot raise this point of limitation again.
As your lordship.
Okay.
But I.
On that day, we will hear the appeal on the merit.
Court, the point of limitation has been closed. Has been
No, my lord.
decided.
That day, if I get a better judgment, I will place, or your lordship has expressed mine, I will go that. If any judgment come, I will
No,
place.
but in light of the concurrent.
Today, it should not be concluded, my lord.
No, no, that is a well settled
Yes,
proposition.
I understood, my lord. Your lordship may not concluded today that points, my lord, it should be open,
No,
that
but
will
I'm
hard hold.
only on the point of limitation. Because he said that there should be an additional substantial
Yes.
question of law on the point of limitation.
Hmm.
That may be decided.
Yes,
As per the.
yes, it's
Let
concurrent.
the regular second appeal come on next week or whatever.
Yes, my lord.
Hearing on that.
My lord, I understood your lordship has said this concurrent judgment, it is not possible. So
Mm.
it let me be open. That day I will argue on that other points. If there is any judgment, we allow to place it like this.
Okay.
My lord, only look at the questions of law which have been already framed.
Yes.
This is on, that's on burden of proof. Because the whole case is, this entire family settlement point or the entire defense of family settlement was never letting, no evidence was led. There was no pleading.
Hmm.
The only pleading is by way of an amended para in the written statement, where they don't even use the word family settlement.
No, my lord.
For a moment, my lord, will kindly look at page 24 for a moment.
28, my lord, court has, learned court has says that there is a family settlement.
Hmm.
Correct. Page 24, 14A, this is the amended claim.
Hmm.
The plaintiff has relinquished the entire claim over the Gauhati property in favor of the defendant in lieu of movable properties, including ornaments, cash in hand, and share of half property and 6,000 property left by the parents, and as such, he cannot claim partition of a Gauhati property and the suit is liable to be dismissed. This is his only pleading. There are concurrent findings of the trial court as well as the first appellate court that the case of family settlement or relinquishment has not been proved, not been established. There is no pleading. There are concurrent findings on this file. I can show it from the judgment. Now, first is that there is no pleading quay a family settlement or quay a relinquishment. Second is his own case is self-contradictory. On one hand, he says that in 67 there was a family settlement or 65 there was a family settlement under which you got Shillong property and I relinquished Shillong property and I got Gauhati property and you relinquished Gauhati property. That is what his case is. He says that in 65, 67 there was a family settlement under which I got the Shillong property, he has no right in Shillong property, he got the Gauhati property, I have no right in Gauhati property. Now, if that was the family settlement, then why in 1991 did he file a suit in Shillong challenging my right over that property in Shillong? Exhibit 11, which my learned friend is showing, is an order passed in that suit, which is a suit filed by him in Shillong against me, saying that I am wrongly claiming 100% ownership of the Shillong property. So, his conduct itself shows that there was no family settlement under which Shillong came to me or Gauhati went to him. Because if that was so, if under the family settlement, I was the Shillong owner, absolute owner of Shillong, there was no occasion for him to file a suit in Shillong.
My lord,
The suit was subsequently dismissed.
yes,
So
this
this
is for
65
default.
This 65, 67 settlement that he's talking about, the family settlement he's talking about, is a family settlement which he himself did not act upon. Because if there was a family settlement and if under that family settlement I became absolute owner in Shillong, why did he come by a suit against me in Shillong?
My lord,
Therefore, what I am saying, my case is very simple. My case is on the death of our parents. 65 the father died, 89 the mother died. Prior to the mother passing away, she gave me the Shillong property as a gift, of which I was the owner. In the Shillong property, when I was about to sell the Shillong property, he came by way of a suit. In that suit, I said that there was no family settlement, but in 74, during the lifetime of the mother, she gave me the Shillong property. Now, based on that, I went ahead and sold the Shillong property. Now, as far as the other properties are concerned, they fell in the common hodgepodge of the late parents, of which I claimed one half share. On this basis, I filed the suit saying that the Gauhati property falls in the common hodgepodge because it was owned by our parents, and I have half a share. So his own case of family settlement is self-contradictory.
my lord, in Shillong, my lord, if my learned friend says that there is a transfer of land, whether there is a documentary evidence that it is gift that mother has gifted him, because mother is 1/3 share, she may give 1/3 share, whether there is a documentary evidence, it is a oral family settlement. Oral family settlement, they get the benefit. The judicial pronouncement is done upon that. Why not in Gauhati? Secondly, my lord, page 27, court has mentioned that,
Mr. Barua,
my lord.
okay, all right, you argue the case on next day.
Yes, my lord. Next.
We'll give a final consideration on that day.
Yeah.
Heard Mr. M.C. Barua, learned counsel for the petition. Then Mr. For the appellant, and Mr. Talukdar for the respondent. Though Mr. Barua has insisted upon this court for framing of an additional substantial question of law on the point of limitation, it appears from the record of the trial court as well as from the appellate court that both the courts have dealt with the issue of limitation and arrived at a concurrent finding of fact. And in that view of the matter, this court is of the view that framing of additional substantial question of law on the point of limitation is not required.
And I may be given my lord one chance, my lord. If not that day, my lord. That is
No,
why
no,
I my prayer. humble
No.
prayer.
No,
Settled question, whatever
No.
question of law, my lord. It's,
no.
if I can satisfy. And today it should not be closed. That day, my
No,
lord,
no, no,
one
no, no.
submission, if I succeed.
We cannot spare time in this
Yes.
way. Accordingly, however, Mr. Borua submits that since a leading counsel, Mr. A.K. Purkaisto, is not present in the court today, he prays for listing the matter after a week for final hearing. Where allow places to list the matter on
38, my lord.
30th as item number 1 in a hearing list.
Obliged.
For hearing, I can take.
Correct. कागजখন ক'ৰবাত সোমালে আপুনি এখন
This matter was earlier taken by Honorable Mr. Justice Devashish Barua.
Pardon?
This matter was earlier taken up by, argued by Honorable Justice Devashish Barua. It's a 2010 matter, sir. Now Mr. Amit Goel will be appearing in this
Pardon?
matter. Amit Goel will be appearing in this matter, my senior. So, some time will be granted. We also need to ascertain the status of the parties, the appellants.
For the respondent.
Okay. Heard, Mr.
Please, Raugi.
Learned counsel for the appellant. No, learned counsel appearing on behalf of Mr.
Amit Goel.
A. Goel, learned counsel for the appellant, and Mr. Hawk, learned counsel for the respondent. Learned counsel appearing on behalf of Mr. A. Goel requested to list the matter when?
After 2 weeks.
After?
2 weeks.
After 2 weeks. This is 2010 matter. 15 years already gone. COVID fixed it.
The month of May. 21st May.
21st May as item number 1 in the hearing list. You come prepared.
Until 9.
itu hearing dia হয় না? Oh.
Lord, in this case, I'm led by Senior Counsel Mr. D. Modinder. He's on lakes in the court. So in the meantime, I may start.
Okay.
Well, in this suit, where the defendant, the suit was declared in favor of the plaintiff and subsequently filed an appeal. Appeal was dismissed. And the question that arose before the appellate court as to whether the death certificate, the exhibit Q, produced by the defendant side to verify or to counter their submission and the pleadings that they purchased a plot of land from one Mr. Gaur Mohan Das, who died in the year 1994, and they purchased the suit land from him in the year 1997. There are other issues involved in the suit. They filed the suit for declaration of right title interest and recovery of possession. So in the year 1996 and 97, they purchased 2 plots of land from some other person. They are not involved in the suit. In the year 1997, they purchased a suit land from one Mr. Gaur Mohan Das, who in the written statement we denied the sale deeds executed in favor of the plaintiff, and we took a specific stand in the para 8 of the written statement that Mr. Gaur Mohan Das died in the year 1994. So the execution of the sale deed in the year 1997 was obtained by fraud, and fraudulent act was done. So the court came to a finding that since the death certificate was produced by the son of the deceased, who has stated before the court on oath that my father died in the year 1994, the court came to a finding that since the other officers were not examined, a medical officer or any connected officer from the authority who has issued the death certificate, so it is not believable. And one more finding in the trial court judgment was that since in the written statement, we did not specifically deny the pleadings made in the plain, so it is deemed to be admitted. So this was the finding the trial court has arrived at, and somehow the learned first appellate court also came to a similar finding regarding exhibit Q and the admission of documents. But the two sale deeds by which they allegedly purchased land from some of the person, third person, they are not involved in the suit, they did not prove it before the court. Rather, the court came to a finding that in paragraph 8 or any of the paragraphs in the written statement, we did not deny the execution, which is not absolutely correct, because in the written statement, we took a specific stand that denying the pleadings made in paragraph 2 of their plaint, because paragraph 2 and paragraph 3, where they have stated about purchase of land from a person, and in paragraph 3, they have stated purchasing a land from Gauramohan Das in the year 1997. If I may take your lordship to the finding of the trial court. So it starts from page 57 of the memo of appeal.
Page number
57, my lord.
yes.
My lord, 58 starts with the plaintiff's case, my lord.
Mm.
On 6/6/1996, the plaintiff had purchased a plot of land measuring 1 katha covered by DUG number 598 of KP Patta number 67 of village so-and-so from Muhammad Khalil Ali. It may be mentioned that on 6/6/1996 itself, the plaintiff had purchased another plot of land measuring 3 kathas covered by DUG number 598 of KP Patta number 67 of Japorigog of village Japorigog from Muhammad Habibur Rahman. Two different persons, they have pleaded that they have purchased some amount of land. The plaintiff took delivery of possession of both the plots of land on the date of execution of the registered sale deeds. Thereafter, the plaintiff had purchased the third plot of land measuring 3 kathas covered by DUG number 598 of KP Patta number 67 of village so-and-so on 3/4/1997 from Gauramohan Das. The plaintiff took delivery of possession of the said plot of land on the date of sale itself. In this way, the plaintiff purchased a total 1 bighah 2 kathas of land. The aforesaid 3 plots of lands are situated side by side and thus from a compact piece of land measuring 1 bighah 2 kathas with a specific boundary shown in the Schedule A of the plaint. After taking over possession of the Schedule A land, the plaintiff erected boundary walls around the 4 boundaries. He had also constructed some houses and kept one caretaker to look after the property. The plaintiff even had let out some of his houses situated over the Schedule A land to some tenants. In fact, the plaintiff has been nurturing an intention to construct a multi-storied building over the said plot of land, and that is why he had not constructed any permanent structures thereon. On 15/6/2003, the pro forma defendant Lokeshwar Datta tried to dispossess the plaintiff from his land and failed. After that, the pro forma defendant Lokeshwar Datta made repeated attempts to dispossess the plaintiff of his Schedule A land. Therefore, the plaintiff had to institute a proceeding under section 145 of the CRPC. The plaintiff claimed that even after the institution of the said case under section 145 of the CRPC, the defendant Lokeshwar Datta continued to disturb the tenants. The plaintiff had to lodge an ejaar before police complaining against the acts of Lokeshwar Datta. Alleging the aforesaid facts, the plaintiff then instituted a suit, title suit number so and so against Lokeshwar Datta. In the suit, the plaintiff prayed for a declaration of his right to possess the suit land and further prayed that in the event the defendant Lokeshwar Datta denies his title over the Schedule A land, then his right, title and interest over the Schedule A land be declared. The plaintiff in title suit number 266 of 2003 also prayed for a permanent injunction against Lokeshwar Datta. In the said suit, an order of ad interim injunction was also granted by the trial court, asking the present pro forma defendant Lokeshwar Datta to maintain status quo in respect of possession of the Schedule A land by the present plaintiff. In title suit number 266 of 3, Lokeshwar Datta had filed a written statement wherein he had disclosed that he had already transferred the suit land of the case in hand to the present pro forma defendant number 7, Konekeshwar Gogoi, in the year 2002. My lord, he is the vendor of the defendant, my lord. Defendant number 7, Konekeshwar Gogoi, who have purchased the land 4 kathas 19 lectures from Konekeshwar Gogoi. Here in this case before me, the present plaintiff has claimed that since the date of purchasing the Schedule A land, he has been in possession of the same and no one else had ever acquired title or possession over his land. The title suit number so and so was subsequently dismissed for default. The plaintiff had filed a petition praying for setting aside the said order of dismissal. In fact, the plaintiff's prayer for setting aside the dismissal of title suit number so and so was filed after expiry of the period of limitation, and therefore a petition under section so and so was filed by the plaintiff. The prayer of the plaintiff for condonation of delay was refused, and the title suit number so and so was not restored to file. Thereafter, the aggrieved plaintiff had approached the Honorable Court, High Court, but ultimately the plaintiff failed to get any relief. The plaintiff has stated after the dismissal of the earlier suit, title suit number so and so, on 31/5/2006, the present set of defendants. Well, this is the main story, whole story of the suit filed by the plaintiff. The present set of defendants, namely Sri Om Prakash Khakolia, Srimati Parvati Devi Khakolia, and Sri Rajkumar Bhartia, had trespassed into a portion of his land measuring 4 kathas 19 lectures. The plaintiff has quoted this defendant as claiming that they had purchased the said portion of the land measuring 4 kathas 19 lectures from the pro forma defendant Konekeshwar Gogoi. The plaintiff then procured a certified copy of the sale deed number so and so dated 2/9/2004 and found that the aforesaid 4 kathas 19 lectures of land is covered by DAG number 598 of KP Patta number so and so with the following boundaries. The 4 kathas 19 lectures of land under occupation of this defendant is described in the Schedule B of the plaint, and it has a different boundary other than that is shown in the sale deed number so and so. The plaintiff has stated that the 4 kathas 19 lectures of land purchased by the defendants do not fall within the 4 boundaries of his Schedule A land, and even then, the defendants have illegally occupied a portion of his Schedule A land, albeit on the strength of the sale deed number so and so dated 2/9/2004. The plaintiff stated that Sri Konekeshwar Gogoi, the vendor of the defendants 1, 2, and 3, had never possessed the Schedule B land at any point of time. The plaintiff has further alleged that the defendant Munmun Saikia is also in illegal possession of about 10 lectures of his Schedule A land. The plaintiff stated that this Munmun Saikia has illegally occupied his land and has illegally possessed the same by constructing an Assam type house. It is pertinent to mention that the plaintiff never stated as to when this Munmun Saikia had entered into his land. The land that has been illegally occupied by Munmun Saikia has been described in the plain as Schedule C. The plaintiff has claimed that he is still in possession of remaining 1 katha 11 lectures of land after being dispossessed of the Schedule B and Schedule C lands. This 1 katha 11 lectures of land has been described in Schedule D of the plain. With the aforesaid story, the plaintiff has prayed that the sale deed of defendant number 1, 2, and 3 is required to be declared illegal and is liable to be cancelled. Well, this is the whole story projected in the plain, which they made a prayer for declaration of right title interest and as well as for cancelling the sale deed executed in my favor by Mr. Konekeshwar Gogoi. So defendant case was defendant has denied the execution of the sale deed, along with in paragraph 8, the defendant has stated that the sale deeds executed in favor of the present plaintiff by Mr. Das, who died in the year 1994, and sale deed was admittedly executed in the year 1997, is a fraudulent one. But this is the crux of the matter, and the learned trial court issues, frame as many as 6 issues. 12 issues, wherein at page 65 your lordship will get the issues. Issue number 5 is whether the deed of sale being numbered 183497 dated 3/4/1997 is a fraudulent one, and whether the defendants illegally disposes the plaintiff from the suit land. There are other additional issues also framed. While deciding the issue number 5, the finding of the learned trial court is as such, which your lordship will find at page 74.
Yes,
It appears that this issue has been unnecessarily framed because there are no pleading in this effect. But during the trial stage, the defendants pleaded that Gaur Mohan Das never executed the sale deed number so and so, as he was dead before execution of the sale deed. The plaintiff has claimed that through the sale deed number 183497 dated 3/4/1997, he had purchased 3 kathas of land from Gaur Mohan Das. The contesting defendants have not disputed this fact in the written statement nor repudiated its execution by Gaur Mohan Das. But during the trial stage, the defendant has claimed that Gaur Mohan Das had already died before execution of sale deed number 1834/1997, dated 3/4/1997. They even produced a death certificate issued by the competent authority to the effect the defendants 1, 2, and 3 had examined Anil Kumar Das, DW4, the son of late Gaur Mohan Das, to prove the factum of death of Gaur Mohan Das and the death certificate. A question arises as to whether this death certificate was indeed issued by the competent authorities. No evidence has been adduced to that effect. In my considered opinion, the witness Anil Kumar Das is not a competent witness to prove the death certificate of Gaur Mohan Das, and for that matter, his evidence is irrelevant in this case. That being this position, the fact of death of Gaur Mohan Das remained not proved in this case. Therefore, I found myself foreclosed against all options but to hold that the deed of sale being numbered so and so dated so and so is not a fraudulent one. This issue is answered in negative. The finding of the learned trial court, my lord, due respect, regarding no pleading in the written statement, and that for the first time in the trial we have raised this issue, my lord, is, in my humble submission, is perverse. If I may take your lordship to the written statement, paragraph 8,
page number.
page number 28, my lord. In paragraph 8, we have replied the paragraph 2 and 3 of the plaint.
No, these numbers are page numbers are different from your.
There's one
So
more.
here it is 48 written statement. Written
40.
statement of defendant number 1, 2, and 3.
Yes. 48. Here I have another copy also of this.
Yes, which
This
paragraph
paragraph
you are reading?
Paragraph 8, minute.
8.
8.
Yes.
That the statement made in paragraph number 2 and 3 are specifically and categorically denied by these defendants, which will speak the inquiry report as it was conducted by the Assistant Settlement Officer, Gauhati, through the Deputy Commissioner, Kamrup, Gauhati, white number so and so dated 12/10/2001. And the said inquiry report, it is annexed herewith and marked as Annexure A. It is pertinent to mention here that deed of sale being 183497 dated 3/4/1997 is fraudulent one, which is learned from reliable sources, as the original Pattadar Gormohan Das, son of Gagan Das, original Pattadar of KP Patta number 67, covered by Dag number 598, was died before execution of the sale deed. So the finding of the learned trial court that we did not take a plea regarding the death of Gormohan Das and the sale deed is not a fraudulent one, but in my humble submission is not in conformity with the written statement we have filed. Because in the written statement, we have replied to paragraph 2 and 3 of the plain. Well, if I may take a lordship to paragraph 2 and 3 of the plain, the lordship will find at page 7. The whole story of the plaintiff covered by paragraph 2 and 3. That the plaintiff purchased a plot of land measuring 1 gatha covered by so and so, district Kamrup within specific boundaries by registered sale deed number 2522 of 96 from owner and pattadar owner and pattadar Khalil Ali, son of plate so and so, on the same day by another registered sale deed number 252396, registered on 6/6/96, the plaintiff purchased a plot of land measuring 3 gathas covered by Dag number 598 of KP Patta number so and so, within the specific boundaries from the owner and pattadar Muhammad Habibur Rahman, son of so and so, on a valuable consideration. On the date of purchase, the aforesaid owners and recorded pattadars were in possession of the aforesaid lands, and they handed over the possession of the land to the plaintiff. The plaintiff took delivery of possession of the aforesaid land. He got his name mutated in respect of the aforesaid land. In paragraph 2, they have narrated as to how, my lord, the two sale deeds were executed in their favor by Khalil Ali and another. In the next paragraph, they have specifically mentioned about the sale deed executed by Gaur Mohan Das. That the plaintiff purchased another plot of land measuring 3 gathas covered by Dag number 598 of KP Patta number so and so Moja Belpala by registered sale deed number 183497 dated 3/4/97 from original owner and Pattadar Sri Gaur Mohan Das, son of Gagan Das, within specific boundaries. The plaintiff got delivery of possession of the aforesaid land from the vendor on the same day of the execution of the sale deed. The plaintiff got his name mutated in respect of the aforesaid land. So, in paragraph 8, we have replied the paragraph 2 and 3 of the plain, where they have mentioned about 3 sale deeds. So the finding of the learned trial court that we did not raise any objection regarding the sale deed, we did not plead it, we subsequently brought this issue during trial, my lord, in my humble submission, is not correct, and which is, my lord, I have just now I have read. Then issue 6, my lord, they decided regarding the possession of the schedule B.
No, Mr. Biswas, you see whether issue number 6 is related to the substantial question of law already framed by this court or not?
Yes, substantial question of law is with regard to the death certificate, the exhibit Q document.
So we have to confine the argument only in respect of the substantial question.
Yes, ma'am. And
So
while
going
framing
by
my
the entire pleadings of the parties will not advance your argument also.
yes.
So
In my humble
please
submission-
confine to the substantial question of law.
Yes. Well, regarding exhibit Q, and my lord, here we have challenged the entire judgment and decree, and the substantial question of law was framed while admitting the, my lord, second appeal. But if there are any more substantial question of law arises during the course of hearing, my lord, I may be allowed to urge, and your lordship may decide it also. Because
No,
if it
that's
goes
all
to
right,
the
but is it your case that any other substantial question of laws are involved herein apart from these two?
well, there are, because the sale deeds executed, allegedly executed by two different persons in favor of the plaintiff, they failed to prove. So the suit was decreed.
No, Mr. Biswas, you say there is concurrent finding of fact
There is concurrent payment.
on all these issues. both the courts below have recorded concurrent finding.
Yes.
So can we again reopen it?
My lord, when the fundamental principle is not followed, my lord, while formulating, my lord, while deciding the case on fact,
Mm,
because your lordship is aware, if they are relying on two cell deeds, three cell
Mm.
deeds in fact, two cell
Mm.
deeds they did not prove. Court came to a finding, since we did not deny it, so it is admitted. My lord, which is somehow contrary to Order 8 Rule 5, my lord,
Mm.
which says specifically denial and if denied. In paragraph 8 of the my pleading in the written statement, I have
Mm.
denied the execution of the sale deed. So
Mm.
the burden is on them to prove the sale deeds. But they cannot get away with the case by placing the sale deeds and not proving this same. The burden is not on us. Burden is on them. Plaintiff has to prove his own case, my lord. This is the
Mm.
fundamental on which, my lord, the suit, in my humble understanding, to be decided. When
Mm.
the fundamentally, my lord, the court proceeded on a noting that
Mm.
since we did not deny the sale deed,
Mm.
so there is a presumption that we have admitted the sale deeds. In my humble opinion, may not be correct. It goes to the root of the case.
Mm.
When they themselves fail to establish a case of right title interest
Mm.
and the documents they are relying on, they did not prove, they did not make an endeavor to prove the document, whether it was right for the courts below, my lord, to decide the issue in their favor.
Mm.
And while deciding the substantial question of law, your lordship may decide the issues, my lord, which goes to the core, to the root of the case.
No, no. Unless we frame any other substantial question of law, apart from these two, we cannot go into the other facts.
Well, it will be,
You suggest that what kind of substantial question of law is involved in addition to these two?
my lord, in my humble submission, the execution of the sale deeds
Mm.
and the proof as per the law of evidence, my lord. My lord,
Mm.
how a document is to be proved, a registered document.
Mm.
My lord, this would be a substantial question of law, my lord, to be framed, because they miserably fail everywhere to prove those documents. And the finding of the learned trial court and the first appellate court,
Mm.
my lord, though it is concurrent, but it doesn't touch the issue regarding the validity of the sale deed executed in their favor.
Mm.
So there are substantial question of law involved in this case, my lord, in my humble submission, apart from the execute Q document.
Mm.
Because in the exhibit Q document also, my lord, when, my lord, as per section 50 and 51 of the Evidence Act, when
Okay,
there is a-
better you do one thing. You formulate the additional substantial question of law. We furnish a copy of the same to Mr. Ali also.
Yes.
We'll hear on that point.
Yes.
If necessary, we will formulate the additional
Yes.
substantial question of law.
Much
If
obliged.
not, we will go by these two substantial question of law.
Absolutely, my lord.
What is your view, Mr. Ali?
What the principle is like this, your lordship, whatever has been already formulated, your lordship,
Mm.
as substantial question of law.
Mm.
All that, let them reply, your lordship, let them argue the matter.
Mm.
If apart from that, they think that they have failed in substantiating those substantial question of law,
Mm.
only then additional substantial question of that is to be formulated under section 100, subsection 4, your lordship.
Mm.
Only then, your lordship. Let them, your lordship, reply on the already formulated substantial question of law, your lordship.
Mm.
Otherwise, your lordship, it should be a endless matter.
Mm.
And now they are not ready also, today also they are not ready, that what are the other additional or remaining substantial question of law apart from already framed two substantial question of law.
Mm.
Because substantial question of law already framed are like this, your lordship.
Mm.
In view of the specifically pleaded case of the defendant, that the executor exhibit 3 had died prior to the date of execution of the sale deed, which was supported by evidence of DW4. The exhibit 3 sale deed could be said to have validly transferred the title upon the plaintiffs in the facts and circumstances of the case. So, but this is content the lawsuit, it's a finding of fact, because what the court found that they have paid to prove because they took the burden to establish that he died earlier to the execution of the sale deed. Very good. Both the court found that they have failed to prove that the executor of that sale deed, that is exhibit 3, your lordship, he there is, they have failed to prove it that he died before the execution of this deed. That is the concurrent finding of fact, Your Lordship. Now, they have taken it as a substantial question of what that goes. Next, whether the findings of the learned court below that exhibit Q as well as the evidence of DW4 was of the probative value is perverse in the eye of law. So that finding, Your Lordship, that challenge as a substantial question of law, that exhibit Q, Your Lordship, which has been there, Your Lordship, that is a copy, Your Lordship. And the court found that he is not the author, this dependent number 4 is not the author of that document. Author of that document is some person, Your Lordship, holding the post and it is GMC, Your Lordship, but they have not actually bought the original record, nor any competent person from the GMC office. And the person who has been examined here for years flatly answered, Your Lordship, that he does not know actually who is the person executing or giving or issuing this exhibit Q, Your Lordship. And that is not the finding of fact. Because of that, Your Lordship, now they are avoiding these two substantial questions of law according to them. So what will be the other additional substantial question of law, Your Lordship? They have not come with that, Your Lordship. That is why, Your Lordship, Mr. Tetli.
So let us fix a very short date. Let them come with suggested a new substantial question of law. We'll see whether the same is involved or not. We'll fix a short date.
Your Lordship, I am just placing the fact, Your Lordship. This is the factual position.
No, that's all right. Therefore, going by this two substantial question of law, the considered opinion of this court, these are not substantial question of law. Because if we go by this two substantial question of law, we have to appreciate the facts, which is not permissible. Unless you demonstrate before this court that the court has committed perversity in discussing these issues.
One perversity I have highlighted before this court
Hmm.
regarding the non-denial of the sale deed in the
Hmm.
written statement, which is, in my humble submission, is not correct.
Okay.
Issue number 5.
You come with the suggested substantial question of law. Heard, Mr. Biswas, learned counsel for the appellant, and Mr. Yasali, learned counsel for the respondent. Mr. Biswas, learned counsel for the appellant, submits that there is a requirement of having additional substantial question of law in this appeal. And he submits that he may be granted some time to come with suggested substantial question of law. We are allowed to recess the matter after 1 week.
1 week, yes.
Okay.
On 7 May, the matter will come for hearing, Your Lordship. And prior to that, will be served with the copies.
Yes.
All right.
Let the matter be fixed, Your Lordship, for hearing.
Yes, hearing.
And the matter may be kept part at Your Lordship.
Okay.
It is a matter of 2015.
Okay, no problem.
Given this,
7th. sir.
7 May. Take it. Take it.
This the matter is parted.
Much obliged.
Item 11.
May it please your lordship. Your lordship kindly pass over the matter for the day. We have informed the other side, my lord.
Ms. Murtaza, learned counsel, appearing for Ms. R. Sodhuri, learned conducting counsel for the appellant with consent from the other side, submits that the matter may be adjourned for the day. We are allowed
Kindly a
this,
date may be fixed, my lord. Kindly a date may be fixed.
Copy.
On 21st May,
Obliged.
item 12.
May I please your lordship?
Hmm.
Your lordship, I did matter and the Thing is this, my lord, we are the defendant in the suit. Huh? We are dependent in the suit and we are the landlord. They are the plaintiff. Plaintiff and defendant, the beneficiary interest of the defendants.
Mm.
They entered
You are
into,
the landlord.
we are the landlord
Okay. So on two ground, the suit was filed.
on the two grounds.
Defaulter and bona fide requirement.
Yes. So no, suit was filed by them.
Okay.
They filed a suit
Okay.
that they are not liable to be evicted by force and they are the tenant under
Okay.
the law. That is their case.
Okay.
And the both courts decreed the suit. We are landlord and he's the tenant.
Okay.
Decreed the suit. And against that, this revision petition is filed.
Okay.
We also filed a counterclaim. Counterclaim to the effect that they are the tenant and they have failed to pay the rent. Therefore, they are defaulted, liable to be evicted. Accordingly, my lord, the issues were framed and the issues were whether the plaintiff has defaulted in payment of rent to the defendant. Both the courts, it is held negative. But the short point involved is in this case, my lord. It is admitted that he is tenant and I am the landlord. And both the courts held that I have failed to prove the tenancy. But in their evidence, in their cross-examination, they very specifically stated stated in the
Pardon?
Kindly allow, Your Lordship, this case is at present this revision is against the dead man, except two respondents, others have died. They are not filed any IA till to today.
Good.
Against the dead man, case is running. Today I got information.
who right? Could run.
Today, Thanaswari Boro, died.
Hey, her name was strike out. Order is there.
Titaram Boro died. Rita Boro died. Next, Komal Boro died.
Yes.
No IA is filed regarding substitution.
Rita Boru died.
Died.
And
The Thanaswari Boro died. Sita Boro died.
no, the name of Thanaswari Boru already struck up.
No,
Thanaswari Boru.
the Thanaswari.
Yes.
Sita Boro died.
Well, your
Sita-
lordship can.
Komal Boro died. Against the dead man case is running.
So none of the respondents are today. The
How? Case is happening.
Your lordship can see the order dated 30/10/2025.
yes.
Appellant number 1, petitioner number 1 and 5 died, and their names will strike out.
1 and 5, that's all right. But if 2, 3, 4 all died, then
They are alive.
alive.
I got information too.
But that order was on the
Yeah.
October 25, that order was passed.
No,
No, 1 and 5 are all right.
Yes, ma'am.
your lordship, no,
Well,
I is the five. As per the procedure, about Guwahati High Court, there should be filed a IA, no IA is the five.
No, no, the question is whether they died or not.
The Thanaswari Boro is the died.
Thanaswar
name
Boru's
is
name is
struck
struck off already.
Now presently alive Rita and Anand Road.
3 and 4.
2 persons are alive.
Alive.
Sita Boru
Sita
died.
Boro died.
When?
Today got information.
Daughter of Bhatteshwar.
No, alive, alive, my lord. Alive, my lord. On October, my lord, 2 persons have 1 and 5, my lord,
No,
expired.
their names are struck off already.
Yes, my lord.
Now the question is whether Sita Boru is alive or not.
Alive. Still alive.
So what is on what basis he was submitting that she died?
I got information.
How can we mention?
The suppressing that. Against the dead man, how the case is elected?
No, that's all right, but your information must be correct. Must be based on some document or like that.
Why another dead? They can be fixed.
Kabu is alive, my lord.
Alive.
That is why, my lord, we have made the prayer.
কনফার্ম করিলা বাহিৰত যা ফোন কৰিলা এইটো কি আছে এভিডেন্স অফ বেনিফিট alive alive confirm
Kabu is alive, my lord. I have just communicated with her. She is alive, 39 years old.
Okay. Okay, continue then.
well the issues they are occupying my house
Mm.
as a tenant by paying monthly rent, and that agreement was executed for 20 years at the rate of rent at the rate of rupees 500, 1500 per month.
Mm.
And 20 years has already been over, and they have not vacated the premises. And rather they have filed a suit that they are they are occupying the property house and they may not be forcefully take out from the suit premises.
Mm.
We filed a written statement
So when the agreement was entered into,
agreement. What was agreement? Immature sessions.
March 1995.
30th March. 30th March 1995.
Point number 2.
19?
1995.
Okay. So 20 years elapsed
Yes.
in the year 2019.
15.
95. 15. 15. 2015.
99 or 95?
95.
Okay. Okay.
And rent was 1500
Mm.
per month.
Mm.
And the rent is to be deposited
Monthly.
monthly.
Mm. Whether there was any time frame within which the rent has to be paid?
7 day of succeeding month.
7 day of succeeding month. 7th day of succeeding month.
Yes.
They have not deposited the rent in time. Pay deposition to possession. Alright, I am here.
The 10 of your evidence.
Malak, the para 10 of the
Evidence of
evidence of PW1 in a court. PW1 Biswajit. Biswajit Kaur.
PW one, para,
PW one, Biswajit Kaur,
para,
paragraph number 10. The, that in case the lawful house rent paying the regularly without fail in the month of May 2012 refused to accept the lawful rent in spite of repeated in spite of request and thereafter availed up to August 2012 and on 14/9/2012 deposited the said rent before the court in NJ case number demand by depositing the said rent the honorable court regularly without fail. That is to pay the monthly rent. And if you also kindly cross part at page 6, handwritten manner.
yes,
Second paragraph. অক্টোবৰ 2011 পৰা মে 2012 মই ভাড়া দিওঁ আৰু মোৰ নিজৰ ৰেজিষ্টাৰ মেইনটেইন কৰোঁ। সেই ৰেজিষ্টাৰ মই এক্সিবিট কৰা নাই। মে 12 পৰা ৰেণ্ট কোৰ্টত জমা দিওঁ। মে, জুন, জুলাই, আগষ্টৰ ভাড়া কোৰ্টত 14/1/12 তাৰিখে জমা দিওঁ। Sorry, 14/9 তাৰিখে জমা দিওঁ। Therefore, he is defaulter.
Mm.
Here it is stated as a monthly tenant. And the monthly tenant, he is in evidence, he is stated that he is depositing rent for the 5 months together.
বেলেগ একো prove কৰিব নালাগে, এইটো judgment দিলে।
so since when he is defaulter?
He is required to pay monthly rent. অক্টোবৰ 2011 পৰা মে 2012 মই ভাড়া দিওঁ আৰু মোৰ নিজৰ ৰেজিষ্টাৰ মেইনটেইন কৰোঁ। সেই ৰেজিষ্টাৰ মই এক্সিবিট কৰা নাই। মে 12 পৰা ৰেণ্ট কোৰ্টত জমা দিওঁ। মে, জুন, জুলাই, আগষ্ট 2012 ভাড়া কোৰ্টত 14/1/12 জমা দিওঁ। 14/9/12 জমা দিওঁ। Therefore, he deposited the rent for the month of June, July, August, May, June, July, August. 4 months together in the court on 14/9/2012.
So
Therefore,
where is the agreement?
Agreement, my lord, the
Exhibit number?
exhibit number A. Exhibit A.
Where is the clause where it is stated that it has to be deposited on 7th of succeeding month? 7th day of succeeding month?
6.
6. First week of every month.
Yes.
Yes.
Therefore, he is defaulted, he is liable to be evicted. The both courts below. Both the courts below. I have two decisions, my lord, regarding this defaulter.
Hmm. How the trial court and the appellate court has dealt with this issue? Defaulter issue.
Yes. Whether the conservation, whether the page 46. Whether the plaintiff is defaulted in payment of the rent to the dependent. The defendant as landlord in his counterclaim has pleaded that the plaintiff defaulted in payment of rent since the month of April 2011 till the filing of the suit, claimed to be evicted from the suit premises. As such, it is the defendant is liable to be evicted as paid for the arrears of rent, realization of business. The defendant in support of his claim has stated that the defaulted in payment of rent since April 2011. Therefore, the plaintiff should be ejected from the suit premises. The defendant claimed that the area rent of rupees so and so from April till the realization of the rent. The defendant in support of the claim adduced by Sita Boro, the legal heir of the original defendant, Bhatteshwar Boro. During her cross-examination, she deposed that the suit land is covered by flag number 217, patta number 56, situated at Kathabari. She further stated that Exhibit A was executed by Father Bhatteshwar Boro. The said agreement, there is no signature in the first page, second page contains the signature. She has not. She stated that the plaintiff as a defaulter in payment of the monthly rent is under the tenant. However, the defendant has not submitted neither any document nor any supportive evidence to substantiate the claim that the DW1, the DW1 in her evidence does not state that the period from which the plaintiff defaulted in payment of rent, and she even know that the rent has been deposited in the court. The defendant said that the defendant side miserably failed to establish the claim of the counterclaim. The evidence adduced by the defendant counterclaimant is not sufficient to establish the default in the payment of the rent in respect of the suit premises. Therefore, defendant is not entitled to relief as paid for the counterclaim. This is the finding of the courts that we have failed to prove. But I have already read out the cross-examination part of the defendant, that he himself admitted that he has not paid rent, and court has, both the courts will overlook that portion of the land, that portion of the deposition. If that portion of deposition was considered by the courts below, then my counterclaim has to be decreed. Decision Saturday. And well, another thing is this, the appellate court held They are the protected under the Assam Non-Agricultural Urban Areas Tenancy Act. But
Mm.
that is not their case.
Okay, pleaded.
That is not their pleaded case. From where the appellate court found that they are protected under the Non-Agricultural Tenancy Act. Don't know.
Not a pleaded case, that is.
Assam non-agricultural?
Alright.
Assam non-agricultural?
Assam Non-Agricultural Urban Areas Tenancy Act.
Some urban areas, non-agricultural.
Sorry, Urban Areas Non-Agricultural Tenancy Act. Section 5,
1955.
1955.
We have rent under the Act of 70.
It was a लिखा a non-agricultural.
Yes, 61.
Huh?
Yes, 61.
Section?
Section 5. And that finding will, your lordship will get at page 61, paragraph number 16. I must herein also point out that Section 106 of the Transfer of Property Act will come into play only in case of absence of any local law. In our state, the state of Assam, an act named as Assam Urban Areas Non-Agricultural Tenancy Act 1955 prevails, which is, in my view, will govern the parties of this case. As per section 11 of this Act, Assam Act, no suit counterclaim is maintainable without the landlord serving 1 month's notice to vacate it.
We have
But-
rent under the Act of 70.
They have claimed the right under the 1979 one Act, 1971 Act. But the court has come to the observed that they are protected under the section 5 of the Assam Urban Areas Non-Agricultural Tenancy Act. That is not their pleaded case. Their pleaded case is this: this is the house of the Pateswar Borough, and the house was they took the rent. In Non-Agricultural Tenancy Act, the land is to be let out to the parties, and within 5 years he has to raise a permanent structure. Then only the tenant will protect it.
And he has to plead that.
There are two distinct different. Urban Areas Rent Control Tenancy Act and Non-Agricultural Tenancy Act. Our case is, their case is also under the Urban Areas Tenancy Act.
We train under that.
So nowhere in their pleadings so they have stated it.
No,
Not a single line.
not a single.
Where is the plaint?
Plaint is at page page 16. 16. That the paragraph number 1. That the plaintiff is a tenant. No, the plaintiff is a tenant lessee under the deed in respect of a plot of land measuring 91 square feet covered by Iman, pattern number 1, holding number C35, located Kathabari, Gauhati 35, Gorsuk Police Station. Mentioned in that as a part of the aforesaid land to the plaintiff. The defendant also owner of a plot adjoining land. The the said plot of land is whether referred to as supremacies. The plaintiff took the aforesaid plot of land measuring 33 2000 for 20 years for the purpose of starting a factory. The defendant also executed an agreement of lease dated 33/1995 in favor of the plaintiff. The terms and conditions stipulated in the lease agreement is a monthly rent in respect of the suit premises, which was fixed as rupees 1,500 per month. The plaintiff further states that the amount of rupees 3,000 as advance rent to the defendant in respect of the lease premises. It may be mentioned that as per that in the year 1995, the Katawari area is not developed and is situated in the outskirts of Gauhati. The plaintiff, after taking the aforesaid suit premises, started a factory, namely Assam Urban Assam Northeast Refactory and Minerals. The plaintiff used the manufacture of clay bottle powder and mostly used the industrial worker. The aforesaid factory now registered in the directory. The suit premises is structured factory. The initially one Mr. Malay Ghosh. Mari kitabখন আছে non agriculture agency.
No, nowhere such play is taken in the pleading.
My lord,
Nowhere in the plaint such pleading is taken, such stand is taken.
no, not taken. And moreover, they have deposited rent under the Assam Urban Areas Rent Control Act. Therefore, from their conduct also, they are the tenant under the Rent Control Assam Urban Areas Rent Control Act, and they are not the tenant under the Assam Non-Agricultural Urban Areas Tenancy Act.
No, whether they have made any reference to this some urban area rent control act,
No, no.
that they are the tenant under the some urban area rent control act.
They have deposited the rent in the court under the Rent Control Act. Therefore, both the petitioner and the respondent are governed by the Rent Control Act.
Okay.
If they have took a plea that we are governed by the Non-Agricultural Tenancy Act, then it will be duty of the plaintiff to prove that the land was given to him. He made a permanent structure within the period of 5 years. That is not the case in the plaintiff respondent.
No, there was a factory in the this
Yes, there was.
tenanted land. Is it not a permanent structure?
No, it is the factory. It is factory. It is monthly rent we have given, madam. We are claiming rent from the house, not from the land.
Hmm. Hmm. No, merely because they have deposited the rent in the court. Can it be said that they have deposited the rent under the Assam Urban Area Rent Control Act?
Yes, madam. That is the proof. That is the proof. They have stated that we have deposited the amount of in the court. Therefore, that they are not paying the rent within 15 days of the coming following month.
Mm.
They are depositing it under the Rent Control Act. The tenant has to pay the rent to the landlord within 15 days.
Mm. No,
15 days.
is there any provision in this act? Urban area rent
No,
control,
there is no provision for depositing rent in the court.
no provision. Okay. 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 So your part is completed.
Yeah, finally, I have two decisions I'll subsequently look into.
Mm.
I have paragraph number 15 and 16. Oh, couple yes.
Mm.
One is Santi Vastralaya versus Varun Kedia,
Mm.
and another is Hemkanto Mehdi versus Mohidhar Kolita.
Mm.
In this Mohidhar Kolita's case, paragraph number 21.
Yes.
And in the Santi Vastralaya's case, paragraph number 15 and 16.
Regarding defaulter.
Defaulters.
Okay. Yes.
Good Lordship, may I kindly allow another short form.
Okay. Heard, Mr. S.C. Sharma, learned senior counsel, assisted by Mr. Vardas, learned counsel for the petitioner. Sir, your name, please?
M. Talukdar.
M. Talukdar, learned counsel for the respondent. Mr. Talukdar. The argument of the petitioner side stands completed. However, Mr. Talukdar submits that he may be granted some time to argue the matter. Fair allowed. List the matter as part heard. On suggested that no. Look. 14th of May. 14th of May. List the matter as part heard. As top of the list item.
Number 16.
Please, your lordship, this matter may not be possible to take the matter now, your lordship. My senior was there, my lord. She just left. Yes, your lordship.
The first time 27/11/2024, this matter was fixed.
Mm.
I have also one suggestion. That if there is stay, it is settled law that filing of petition does not operate as a stay, and the decree cannot be doesn't matter.
Mm.
Immediately took that, and there is no revisional jurisdiction. 115 cannot entertain, my lord.
Mm.
As per section 11 of the Land Revenue Act, we have proved our honors.
Mm.
And they did not produce any evidence before the SPPL court.
Mm.
And right now they have produced one sale deed. At that time they did not produce. They suppressed that deed. Sale deed.
Mm.
And this petition cannot be entertained under section 150. It's not maintainable. There is no perversity.
Okay.
Only immediate right. We took that.
They will
Maybe
take time, your
cancel.
lordship.
Registrar list the matter and the hard miss Murtaza,
Yes, sir.
learned counsel for the petitioner, and Mr.
A.K. Hanan, madam.
A.K. Hannan,
Yes, madam.
learned counsel for the respondent. Processor lays the matter on
Short date may be given.
Shortly, maybe.
28. As top of the list item.
Oblige all. Interim.
Interim order shall continue till then.
Oblige all.
Item 70.
Adjourn next week.
Hmm. Heard, Mr.
Castellum.
Learned counsel for the appellant. Then also heard Miss
J.N. Kandakar. J.N. Kandakar.
J.N. Khandokar, learned counsel, appearing on behalf of Mr. J. Ahmed, learned conducting counsel for the respondent. Ms. Khandokar submits that Mr. J. Ahmed left the court.
Yes.
Left the court. And on such grounds, he pressed for listing the matter. After a week, parallel basis, list the matter after a week. Will not fix any date.